Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a confidence of concern, or
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
Good morning, good Friday morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Sorry, I was lost in the audio. Wasn't paying attention to the fact that the video was not on. My screen is dark. I've messed up the settings on my TV. Maybe I can fix this live. Picture mode. Oh, now it's really dark. Vivid. Game. Computer looks pretty good. Let's do computer for a minute. Let's do back. Computer and then crank up the brightness. Now we're cooking. Now we're cooking with fire. Okay, that's good. That's good. All right. I can live with that. Good morning, everybody. Happy Friday. We made it all the way to Friday. If you guys missed the podcast yesterday, it was an absolute blast. You have to put it on your rewatch list. It's a requirement. It was so much fun. Thomas, thank you once again, my friend. It's a blast doing that once a week. Let's see. No Pants Friday. Yes, No Pants Friday. So waist up only shots today. Let's see. I've got some other things going on. Hang on just one second. We've got, I think we have, oh, would you look at this? Would you look at this? Hang on, guys. Donnie, my friend. How's it going? Happy Friday to you.
If they didn't, I would lose my mind.
I would lose my mind as well. Donnie, first in chat this morning. First person through the door and blurt something out in the chat window. Congratulations, Donnie. Not sure if you know this, but being first in chat, I mean, you're bragging about it now. I see it in chat. You're like, yeah, I did it. It was me. First in chat is it's both a good and a bad thing, because we were enjoying the peace of the morning. It was quiet. We were just chilling. Everyone was just like a little bit of Zen moment, and you come barreling through the door yelling hi, and it sort of just it shook us to our core. It happens every day, and I don't know who won. Because you did this, and as I can tell, you did it intentionally. There was plenty of intent here. We're going to punish you, Donnie. Both congratulate you and punish you at the same time. We're going to punish you with, yes, I was shook, says Petrified. I was shook. We're going to punish you with internet ownership. You'd think, hey, owning the internet seems to be a good thing, right? Well, you don't get the good side. You just get the I have to fix it side if it breaks. So maybe even for the whole weekend, as Ashley points out appropriately. Many of us are still shook. And Donnie, congratulations. The internet is all yours. Donnie, you might be able to spin this in your comedy career. You might be able to spin this event and maybe make some money off it down the road. But today is pretty much just going to suck for you. And for that, I sort of apologize, but at the same time, I have no remorse whatsoever in handing down this punishment to you. You are now the owner of the internet. I've gifted it to you. All people worldwide are going to call you with any problems they have IP related. So we'll make that connection happen on the back end. Your phone's probably going to get a little busy. A little busy. You might not have time to call as much today because of that. But tomorrow's a new day, Donnie. Well, Monday's a new day. You might have all weekend. So let me just say, Donnie, good luck and a little bit of good riddance. I had the internet, briefly. That's how I gifted it to you. If you do want to commemorate this momentous occasion, you can go to our shopping page on the YouTube channel. And if you scroll through far enough, you will find that for the low fee of 50 cents, you can request a copy of your own.
Burger King. People do not get to have it their way.
I was going to say rap sheet, but it's an internet ownership certificate pre-signed by myself and my boss, Mrs. R.A. You just have to fill in the blank with your name on it. But you can download that. It's a digital download for 50 cents. All the money goes to YouTube. I make 0 pennies on that. That's just it's a straight fine. You're paying a fine. There's no profit in there at all for me. But that certificate is suitable for framing as well as for use on a cover sheet on your resume if you so choose. Congratulations, Donnie. We are all shook. We are getting ready to jump back to the Carly Gregg trial, which should have closing arguments this morning. Before we do that, we are going to do the birthday song, which means all of us together, collectively, several of us individually have birthdays, and collectively we're all going to sing to them. So just doing the math, there should be a fair number. And look at this. Sharon says, first she sends the buffer sound.
I think I'm about to catch a whooping.
That's not it. That's the Donnie sound. There's the buffer sound. Looks like we have Natalie, Tommy Jones, Backpack, Tom, 2 Toms, Maddie S., Emily Ahrens, Trisha, Christy Colette. That's a lot to fit in one verse. But we're going to try it. We're going to try to fit everyone into the birthday song. If you have not ever done this, and add Adam. Sharon, can you retype all that and add Adam to that one? Because Grace Sanchez has a son, Adam, with a late ad. Let's see. I can probably do it. Copy. This is me using technology. Copy. Now I need a keyboard that works. Okay, here we go. Adam. Now I have the list right there. Okay, thank you, Sharon, for that. By the way, I got it. I did it myself. If you have not done this before, if you have not started, okay, hang on. Now we have 2 to add. Give me a second here. Let's take a call while I'm working on this.
Call from.
It's me.
Donnie, I can sense the regret in your voice already. What's happening, my friend?
Thank you. Thank you so much. I never wanted anything like this before in my life. Been watching for almost a year. I haven't thought that this would come through because usually green is red pen. Before me. I just want to thank you. I want to thank you for the chat. Thank you so much. I'm so sorry. Bye-bye.
Bye, Donnie. It can get emotional. Winning chat is a big thing, and this is the first time for you. So, congratulations. I broke something. Hang on one second. I broke chat. I need to find. Okay, we had Adam, and what was the last one? Poor Donnie. He's crying now. Wait till a little later. Once the calls really start coming in. Okay, we have to have Mary. It's going to be a 2-verser for sure. I missed the other one. Mary, Jonathan. Okay, somebody said there was somebody else. Let me tell you who I have right now. And I apologize if I missed somebody. We've got to sing and then go to court. Natalie, Tommy Jones, Backpack Tom, Maddie S., Emily Ahrens, Trisha, Christy Colette, Adam, Mary, and Jonathan. Let's see. Add Saraboo. Okay, Saraboo. Is there anybody else I missed? I think that's it. Okay. All right. So I'm going to put these up on the screen. We've got the Sarah and Jamestown. Okay. All right. List is on the screen. This is the official list. This is what we're going to sing to. I'm sorry if we missed anyone else. We're not going to sing to Sarah Boone. But if you've never done this, if you've never joined with us, if you've always just sat and watched and thought, oh, that's fun, he's singing. No, it's actually all of us. And you actually feel the all of us if you join in the singing. So please, if you would, warm up with me. La 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 la. Excellent, excellent. We're now going to sing the happy birthday song. It's going to be 2 verses. I'll split this right about the middle. Keep them on the screen for everybody to see right here. Oh, okay, here we go. Happy birthday to you. Happy birthday to you. Here we go. Happy birthday, Natalie. Tommy Jones, Backpack Tom, Maddie S. and Emily Arens. Happy birthday to you. Okay, we've got all these ones left, plus the late ad of Kyle's mom and Maddie Sanborn. Oh my goodness. Okay. It's a rough day for birthdays. Lots of people born today. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Trisha, Christy, Glenn, Adam, Mary, Jonathan, Sarah, Boo, and Jamestown. Happy birthday to you. One more verse. Happy birthday to you. Happy birthday to you. Happy birthday, Kyle's mom and Maddie Sanborn. Happy birthday to you. Whew. 3 verses. September, what happened 9 months ago? Never mind. There are a ton of you had birthdays today. It must have been cold January. Yes. That is wonderful. To everyone who celebrated a birthday, I can't put you all back on the screen right now. But I realize there are a million places you could be, a million people you could be with, but you've chosen to be here with us. Thank you. The privilege and pleasure is all ours. Hopefully we can make your day a little more special. And we can do that, first of all, by singing to you. And second of all, by having some other company give you something for free. And today that's going to be IHOP, Denny's, Village Inn, maybe Waffle House. Get your free stack of pancakes on your birthday. It's a great way to kick off your birthday. And other than that, have an absolutely beautiful, beautiful day. If there's anything we can do to make it better, please let us know. I mean, Jennifer's given it her all. She really is. So it's all for y'all. We're going to finish the song. This drum cue. We have a big air drum finish, and if we can all play together, it will be just deafening, as air drums across the world will be playing. Get your drumsticks ready. Here we go. Beautiful, beautiful. Those toms there on the finish. It was wonderful. Happy birthday, everybody. I feel better already just singing to y'all. Thanks. I felt it. It's Kyle's mom. Is it Kylie's mom? I think I might have called you Kyle's mom. I apologize. Please play the Roaches fighting clip. I've got to see it. The actual clip? I only have the audio. I'd have to go back and find that somewhere. TYO Toys on Twitter is probably your best bet to find that. He has all the best bits saved.
Somebody just sent me a video
but I don't know if he's
Roaches fighting. I don't know who won.
Have him send someone with more experience.
I don't know if he's got them like categorized on dates when you can find things. Let's see. Has anyone heard of the new defense for Sarah Breen? Yes. She's gone to not intentional to self-defense, which is a big jump. Big jump. Holly Mack nailed the drum ending. Hey, years of practice, it will get you there, Holly. This is proof. Congratulations. I mess up the drum ending all the time. The worst part for me is the audio happens in my ear like a split second different than what's on screen. And so I'm not sure if I'm off or delayed to make it look right for you guys. I don't know which one it is. Tell us the background of the clip of the Roaches fighting. This was Judge Stephanie Boyd. And as we do this, I'm going to just say we are getting ready for court. So hold on just a second. We're going to be there in just a minute. Judge Stephanie Boyd in Bexar County, Texas. Great judge. Huge heart and takes no guff from anybody. Hang on. I've realized I'm missing the counter.
Bring the jury.
All right, we needed the counter there in the corner. Great judge, amazing. Nope, that's not it. She was telling people they don't want to go to jail, and the jail's a really bad place. And she's describing it, and she says, somebody sent me a video from jail of cockroaches fighting. It's just as you don't want to be there. She did a better job explaining it than I did, but that's where the soundbite came from. She always comes up with little things like that. We've got a few from Judge Boyd that we really, really love. Before we kick off court, which looks like people are just arriving right now, so we just got a moment, I've got to say, Denise Feldman Ursland gifted a membership this morning. Thank you very much. Amy Flo, congratulations on 7 months. Judges here. Red Pen gifted a membership. Kimby, member for 14 months. Jennifer Juniper gifted a membership this morning. Kansas Sunshine DJ, member for 9 months. Woohoo, high five me, best channel ever. Thank you. Thank you. Itchy Withers Horse Rescue, also member for 1 month. Happy birthday to you all, and congrats to Donnie. Thank you. Congratulations on all those membership milestones as well.
Anything overnight needs to be dealt with by the state.
Yes, sir, Your Honor.
By the defense.
Yes, Your Honor.
All right. As soon as they tell me the jury's ready, we'll get started. Y'all have your equipment hooked up?
Yes.
Apparently, we're just waiting on the jury this morning.
Sure.
Brybear, good morning. Thank you very much. Happy 5 months. Member on the jury, by the way. Nice padded seat on the jury. We have a majority of members are in the gallery, which is great. Front row seat, it's fabulous. Jury members, their virtual seat is padded, and it's a little bit better view. You're a little bit further forward. You can hear a little better, and then we have a select few who Greeners became part of yesterday, who are attorneys and who get to actually walk around the well of the courtroom and sometimes even approach the bench.
Just subject matter jurisdiction.
Thank you all for your support on the channel. It wouldn't be possible without you, and I'm heartfelt, and I mean this. Thank you. We are going to finish watching Sarah's verdict. We're going to do that during Verdict Watch, if that's all right. Or we're going to watch Sarah's hearing during Verdict Watch, because we're going to have a long period of nothing happening. But that's when we're going to pull that one up. Okay, let's go full screen there. Carly's got another can of, looks like cherry Coke today, possibly. Or is that Dr. Pepper? I didn't see. I had this text covering it. And I had forgotten to start my recorder, so I don't even have a way to rewind. But I can rewind now. Oh, that was a keyboard. I'm just breaking things here, guys. Sorry.
Bring the jury.
I don't. Did she just say I love you? Did the girl next to the grandparents just say I love you? They're fairly consistent on what they tell her, which is cool, but 19th, 20th.
I think I'm about to catch a whooping.
I think I'm about to catch a whooping. That was the best soundbite ever. Okay, I don't know why things are not working here on my end. Just 1 second. I've got to shut down DaVinci Resolve. All right, just missed a couple comments. Give me just a second. We'll catch up here. Ooh, look at this. Holly Mack just gifted 5 memberships. Congratulations to the winners, and thank you very much, Holly. That's super, super generous of you. Good people got gifts, every single one of them. I can vouch for every single one. Counter went up so much yesterday. Yes, we're up to 242. It's really been climbing. There's a couple people in particular who add a lot to the counter. Does Ashley have a sister? I know she had a sister that passed away years ago, I think as a child. My hubby has surgery on Monday. Ask her for prayers and good vibes our way. Thank you, good friends. Bug Dugger, thank you. We'll keep him and you in mind. Yeah, please know that we've got your back. We're thinking of you. If there's anything we can do, please let us know. And thank you for sharing. Ricky C. gifted 5 memberships. Thank you, Ricky. Very generous as well. Another 5 great people in green now. Mistrial, member for 5 months. I have no words that everyone else hasn't already said. Well, no one else has said that. Congratulations on 5 months, Mistrial. Wonderful. It would not be the same without you here. Thank you. Let's see. We have watched one of Carly's last pretrial hearings. I don't have all of them ready, and I don't want to start any that aren't good, like that are just boring, but we've got some other stuff to cover. It depends how long Verdict Watch goes. I'll say maybe we can do that. They shouldn't be allowed to talk to her. This is interesting. A lot of people have brought this up. Every state is different, and not just every state is different. Every court is different as far as what the judge allows and what they don't allow. I mean, we saw a judge in Nevada that doesn't allow double negatives, and that's a first. This court, the jurors are not allowed to take notes. Other courts, they're instructed to take notes. There's varying as far as positioning. The court is laid out a little bit differently with both the prosecution and the defense on the right-hand side of the judge as he sees you in the courtroom, the well in the middle, and on the left is the jury. Normally we have the prosecution and defense facing the judge, but this layout sort of makes it just as easy for Carly to look to the judge as it does for her to look to the gallery, because it's just a change of direction. And this court does seem to allow communication back and forth. There are some times where we see a defendant, specifically one who's very upset with or has audience members that are very upset with them, where the judge will say, hey, no interaction, cut that off. We don't want you antagonizing the victims or anything else. And we've seen that in other cases. But in this one, he's cool with them talking about it. Back and forth. It's just a little different. That's why we love jumping around the country so much to watch courts, because you get something different every single time. Trial TV Live has a stream with them all together. I'm pretty sure I could talk to Trial TV Live and get permission to use their stream, or we like to work together, two of us. We'll check that. Thank you, Green Eyed Cat, for the tip on that one. Stepdad is allowed back in. I'm not sure if he's working. I mean, not everyone is able to just take off as many days as somebody has in court. So he might be a late arrival or not be able to be here on every day. Trail TV Live is a great channel. They are. I've spent a lot of time on the phone talking with them and working out some things we're trying to do in the future, especially with Sarah Boone. We're still working on. Do all courts there not allow people in the court to stand? Grace, this is the first court I've ever seen that tells people, sit down, the jury's coming in. Stay seated, the jury's leaving. Never seen that before. Still no audio from court. Waiting for, I think we're bringing the jury.
Bring the jury.
Okay, I need to find a place for this battery. It's a bit nerdy, but I've found that some of my gear performs better, meaning the audio is clearer, if it's charged off a battery instead of off an AC, because the AC current might carry a hum behind it, like a 60 hertz hum or something. And my phone being charged is one of those things. The phone charger cables I use just are not clean. They don't provide clean energy, clean sound, electricity. And so I have to charge it off a battery during the day. So I have a huge battery that will run for like 3 days. And I hide it under my soundboard. But I'm a member, but I've never had a court by my name, says Marlene Marshall. Thank you so much. Marlene, subscribers are... the subscribers in chat are in white. The membership, if you want to check, if somebody can type one of the mods, if they can type the gift setting, GIFTS, it needs an S on the end. There's a link you can click on to double check to make sure that your gift setting is turned on. There it is. It's right there. You click on that, and you want to make sure the slider is moved to the right. That would enable you to be eligible to receive a gift. If you're a member on the channel and you're logged into the account that has a member, then has memberships, then you should hang on.
Your verdict. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in these instructions by the court. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw. Let's hold down the talk in the audience. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw any inference therefrom. The order in which these instructions are given has no significance as to their relative importance. It is your function to determine the facts in this case and to consider and weigh the evidence for that purpose. You are to apply the law to the facts and in this way decide the case. The evidence which you are to consider consists of the testimony and statements of the witnesses, any stipulations made by the attorneys, and any exhibits admitted into evidence. You are also permitted to draw such reasonable inferences from the evidence as seem justified in the light of your own experience. It is your prerogative to determine what weight and what credibility will be assigned the testimony and supporting evidence of each witness in this case. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. The production of evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court or the judge has any opinion on the merits favoring one side or the other. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inference from the content of these questions. You are to disregard all evidence which was excluded by the court from consideration during the course of the trial. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty of every material element of the crime with which she is charged. Before you can return a verdict of guilty, the state must prove that the defendant is guilty beyond a reasonable doubt. The defendant is not required to prove her innocence. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 jurors must agree on any verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberation, do not hesitate to re-examine your own views and change your opinion if convinced that it is erroneous, but do not surrender your honest convictions as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The court instructs the jury that the defendant has a constitutional right not to testify at trial. You should not draw any inference from the defendant's failure to testify. The defendant's failure to testify should not in any way be considered by you during the course of your deliberations. The court instructs the jury that you have heard testimony from expert witnesses. Persons who by education and experience have become an expert in some field may state their opinion on matters in that field and may also state their reasons for the opinion. Expert opinion testimony should be judged just like any other testimony. You may accept it or reject it, and you may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all other evidence in this case. You are instructed that the indictment creates no inference of guilt, and the fact that the defendant was indicted shall not be considered as evidence against him by the jury, and no inference of guilt can be drawn therefrom. You must not base your verdict solely on the number of witnesses for either party. The defendant, Carly Madison Gregg, has been charged by indictment in count 1 with the crime of first-degree murder, in count 2 with the crime of attempted murder, and in count 3 with the crime of tampering with physical evidence. Count 1. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of first-degree murder. You find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. With deliberate design to effect the death of Ashley Smiley, then you shall find the defendant guilty as charged in count 1. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 1 of the indictment. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of attempted murder. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously attempt to kill Heath Smiley, a human being, but failed to complete the act, then you shall find the defendant guilty as charged in count 2. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 2 of the indictment. Count 3, the court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of tampering with physical evidence. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously intentionally destroy, mutilate, conceal, remove, or alter physical evidence with intent to impair its use, verity, or availability in the pending criminal investigation or prospective official proceeding, then you shall find the defendant guilty as charged in count 3. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 3 of the indictment. The court instructs the jury that there is a presumption that an accused is sane, and therefore the burden is initially on the accused to introduce evidence which creates a reasonable doubt as to her sanity at the time of the act. However, once the defendant has created a reasonable doubt as to the defendant's sanity, it is the burden of the state to present sufficient evidence to prove the defendant's sanity beyond a reasonable doubt. The court instructs the jury that the following is the definition of insanity in Mississippi. Insanity exists when at the time of committing the act, the accused was laboring under such defect of reason from disease of mind as 1, to not know the nature and quality of the act she was doing, or 2, if she did know the nature and quality of the act, she did not know that what she was doing was wrong. The court instructs the jury that if you find that the state has proved beyond a reasonable doubt all the essential elements of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, then you must find the defendant guilty of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, unless the state of Mississippi has failed to prove beyond a reasonable doubt that the defendant was sane at the time the defendant committed the crimes of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence. In order to prove the defendant sane at the commission of the crimes of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, the state must prove beyond a reasonable doubt that at the time of the commission of the crimes of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, the defendant had the mental capacity to realize and appreciate the nature and quality of her acts and to distinguish between right and wrong with reference to the act she committed. If after considering all of the evidence in this case, you find that the state has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the crimes in count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, then your verdict must be not guilty by reason of insanity. The court instructs the jury that if you find that the defendant, when sober, is capable of distinguishing between right and wrong, and the defendant voluntarily deprives herself of the ability to distinguish between right and wrong by reason of becoming intoxicated and commits an offense while in that condition, she is criminally responsible for such acts. The court instructs the jury that when all 12 of you reach and agree upon a verdict as to the indictment, you shall return the verdict to the court in one of the following forms. Count 1. Should you find the defendant guilty of first-degree murder as charged in the indictment, then state your verdict as follows, quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment, close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quote. Or, quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of first-degree murder, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of first-degree murder. Close quotes. Count 2. Should you find the defendant guilty of attempted murder as charged in the indictment, then state your verdict as follows. Quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quotes. Or, quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of attempted murder, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of attempted murder. Count 3. Should you find the defendant guilty of tampering with evidence as charged in the indictment, then state your verdict as follows. Quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quotes. Or, quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of tampering with evidence, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of tampering with evidence. Close quotes. Write your verdicts on a clean, separate sheet of paper. It is not necessary that you sign the verdicts. Counsel for both sides will now have an opportunity to address you and make their closing or final arguments. The arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but they are not evidence. The attorneys in making these arguments to you will be commenting upon the testimony that you have heard and the evidence that has been presented in this case. They, as you, will be recalling the evidence that has been presented. They should not intentionally try to mislead you. However, if their recollection of the evidence differs from what your recollection is, you must follow your own recollection. If any argument, statement, or remark has no basis in the evidence, then you should disregard that argument, statement, or remark. Jury instructions will be on the bench in front of the court. If either side needs them, you can come get them. If you use them, return them in the same order you picked them up in.
So look at the typos
on behalf of the state.
in my question, my poll messed up the question so badly. There's a poll up right now, Kaylee. Everyone's got Cokes today. We now have 40 minutes for prosecution, 40 minutes for defense. I think the prosecution should go first and last.
Please, the court. Good morning, ladies and gentlemen. As Ms. Todd stood before you on Monday in her opening statement and told you this is not a case about who did it. And in fact, all of the evidence that you've seen tells you exactly that. It's not a case about who did it. You haven't seen one shred of evidence in this case that what happened on March 19th, 2024 was caused by anyone other than Carly Madison Gregg. The defense also told you during opening statements on Monday that the state wants you to leave your common sense at the door, that they want you to tie it up in a bucket and leave it at the door. Ladies and gentlemen, all we want you to do in this case is use your common sense. And in fact, that's what Judge Arthur just instructed you to do in the very first jury instruction. And I want to talk about a few of these jury instructions with you real quick. But in jury instruction number 1, which you'll have back in the room with you, on the second page, he instructs you, you're required and expected to use your good common sense and sound, honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. Ladies and gentlemen, on behalf of the state, all we want you to do is to go back there and use your good common sense and your sound, honest judgment. And again, I don't believe that you've heard one shred of evidence throughout this entire week that the person who shot Ashley Smiley was in fact Carly Madison Gregg. The person who shot and attempted to kill Heath Smiley was Carly Madison Gregg. And the person who took down the camera from the kitchen and hid it in the refrigerator behind some water bottles was Carly Madison Gregg. Now, Judge Arthur also read you the elements of the crimes. And again, you'll have this information back there with you in the jury instructions. It's jury instruction number 8. And I kind of want to go down because as a simple person myself, I like to kind of have a roadmap as to where I'm going. So I like to be able to look at things and see them on paper. And that's exactly what these jury instructions provide you, kind of a roadmap to help guide you in your deliberations. So I want to talk about count 1, which is the first degree murder. And there's 3 elements here that it has listed. And the very first one says that on about the 19th day of March, 2024 in Rankin County, Mississippi. That's the first thing you have to find. Ladies and gentlemen, all the testimony has been that this happened on March 19th, 2024. You heard from Deputy Hunter Lewis, who was the first deputy who arrived on the scene there, that he was called out that day, that he received a call from dispatch to respond to 214 Ashton Way, which is in the Farmington Station subdivision off of Old Fannin Road. And you heard Mr. Kevin Collins, the 911 dispatcher, who told you that the call out came on that day at that time about 5 o'clock in the afternoon. And you heard them tell you that obviously Farmington Station is located in Rankin County, Mississippi. So there's no question as to that first part of the element there. As to number 2, that the defendant Carly Madison Gregg did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. Well, ladies and gentlemen, you heard from Mr. Cliff Dunlap, the deputy coroner, who told you that the manner and cause of death in this case was found to be 3 gunshot wounds to the head, and that it was found to be homicide, and that the victim was indeed identified as Miss Ashley Smiley. The last part there is that she did it with deliberate design to affect the death of Ashley Smiley, the victim. Ladies and gentlemen, I would submit to you that in the state of Mississippi, when it talks about deliberate design, that it's simply talking about an intent to kill. An intent to kill the victim, Ashley Smiley, that she did this with an intent to kill. And I would further submit to you that the use of a deadly weapon is an intent to kill. Whenever you aim a deadly weapon, a pistol, a .357 revolver, at someone's head and you shoot 3 times, that's certainly an intent to kill. Now, again, it's not a case about who did it. And I'll show you some of the video here in just a second. But let's think about what happened that day. So you remember from the video, you saw from the garage, you heard several witnesses talk about it, that earlier that day, Mr. Bennett Germany and another friend, Sarah Catherine Rayleigh, who the defense put on the stand yesterday, you heard from them, and they said they devised this plan to go talk to Ashley, to go talk to Carly's mom, because they were worried about Carly. They were good friends. They were worried about Carly, and they were worried about her drug use, her use of burner phones. And I just want to be clear, ladies, this is not a case about marijuana and whether or not she was smoking marijuana. This is a case about whether or not she was intoxicated, voluntary intoxicated. You heard me talk to Dr. Clark about that she would, one of these times that she says she has one of these events where she supposedly zoned out. That, in fact, what happened was that she went and smoked marijuana. It could have been any drug, but it was just marijuana. And she zoned out, and she had this event where supposedly she says that she, fell out on the floor and whatever happened. And she did that after her mom and Heath left one day and went to the grocery store. But I just want to be clear, it's not a case about marijuana. It's simply a case about, her actions. And so Bennett and Sarah Catherine, they devised this plan. They're going to tell Miss Smiley. Well, Obviously, you heard testimony that one of the things that Miss Smiley was worried about was her daughter, Carly, the love of her life. You heard that she had another daughter who died at a very young age from some type of genetic disorder that she had. So you got Carly here. She's the love of Ashley's life. Obviously, she's disappointed, probably a little bit sad, probably worried for her daughter. And the last thing that she wants her to do, according to the defense, is turn into her dad, right? Her biological dad, who you've heard about, who obviously liked to use a lot of drugs, abuse a lot of drugs. So at some point, she confronts Carly. She searches her backpack, whether in the car, on the ride home, or at the school. And then you see them get home, and you heard Dr. Pickett talk about it yesterday, that the situation seemed a little bit tense, right? That they get out of the car in the garage. You don't hear, they're not talking to each other. And they go in, you see Ashley put her coat and her phone down on the bar there in the kitchen, and she proceeds directly to the side of the house where Carly's room is located, presumably to start searching through Carly's room, right? And so you see Carly kind of walk back and forth. You see her walk there to the living room area and kind of listen to see what her mom's doing. At some point, she eventually takes the dogs out, right? I don't know what happened while she was outside, ladies and gentlemen, but at some point, whenever she was outside, she made up her mind, if not long before. We'll talk about that in a second, her conversations with her friend from MSMS, Thad, that you heard from. But at some point outside, she makes up her mind exactly what she's going to do. And she comes back in from taking out the dogs. She walks there to that living room area, kind of listens to see if her mom's still in her room. And then without hesitation, she walks, as Dr. Pickett said, to the side of the house, her mom and Heath's bedroom, where this pistol is located. She knows it's located there. Now, they want you to believe that from the time she brought the dogs back in or took the dogs out, that she blacked out at that point. You heard me ask Dr. Clark. Well, from the time she took out the dogs to the time she was arrested by Deputy Shack, who you also heard from, that she was blacked out in that period. Well, that's a real convenient time to be blacked out, right? And so she brings the dogs back in, and she goes directly to her mom's room and Heath's room, and she retrieves this pistol. And you see her walk back across the screen. Well, when she gets there, she looks around the corner into the kitchen to make sure that her mom hasn't come out of her room, knowing exactly what she's doing. Cool, calm, calculated, and callous. She walks directly. She proceeds to her room, and a couple seconds later, you hear the shots. Boom, boom. You hear two shots within 3 seconds of each other. You've seen the pictures. You heard Dr. Pickett testify yesterday. Two well-placed shots right to the side of Miss Smiley's head, a relatively small target. And then a couple seconds later, boom, you hear a third shot right under the chin. And we believe it's right under the chin is the third shot. We know it's right under the chin. We believe it's the third shot. You heard Deputy Investigator Burnell talk about the stippling, the powder burn around the shot, right? And he tells you that based off his training and experience, that shot had to be within 36 inches because that's when you see stippling, the powder that comes out that's still ignited, that doesn't have time to burn, and it burns right here on Miss Smiley's face. And then what does she do? Immediately, you'll see on the video that happens at 4:14 p.m. Immediately, she comes back in. She gets on her mom's phone. She has the wherewithal to enter her mom's code onto her phone and to text someone specific. And that someone specific was her stepdad, Heath Smiley. And you'll see that text message was sent within the same minute, 4:14, that she shot and killed her mom. And what did she say to him? Something to the effect of, "When are you going to be home, honey?" And it's perfect grammar. The comma's in the right place right before honey, right? She knows exactly what she's doing. She comes in there. She knows exactly where the camera is. She comes. She's got the gun hidden behind her. She slides down into the chair, and you hear her put it down on the bar stool. You can hear it whenever you get back to the jury room. You'll be able to hear that. She puts it down. And you hear Dr. Pickett talk about she's got the wherewithal to know exactly where the dogs are. The dog walks behind her. You'll see it. He walks behind her, and she knows let me make sure he doesn't knock the gun off. Right? At some point, she begins text messaging her friend. She shoots her mom at 4:14. Then she invites her friend from school, who you heard from, Brooke. She invites Brooke over. You'll see the messages between her and Brooke. They're in evidence. And you'll see where Brooke texts her at 4:58, basically 45 minutes later, and says, "I'm here." Brooke had no clue what she was about to walk into. Carly meets her at the door, says something to the effect of, "Have you ever seen or are you squeamish of dead bodies?" Well, Brooke says, "I don't know. I've never seen a dead body." Not thinking that there's a dead body currently in the house. Right? Carly's walking around with the gun. Carly leads her back to the room and shows her dead mom, who's got her arms crossed over, who's been posed. Right? She's posed her mom at this point. She's put her arms across her. She's put a red towel over her face. Again, cool, calm, and calculated. She knew exactly what she was doing. She knew exactly who to reach out to during this time. She's reaching out to all of her friends. You heard from multiple friends that she reached out to. You heard from her friend Thad, who she was texting, and actually before they text, she calls him on FaceTime. And what does she tell him? Well, she tells him, and excuse my language, "I fucked up." Right? Well, how do you know you messed up if you don't know what you did? She knew what she did. She knew the difference between right and wrong. So she obviously tells Thad, but she can't tell him what she did. She knows she can't tell him over the phone. Well, then, being a good friend and being worried, Thad begins to text her after they get off the phone. And they're messaging. Well, of course, in the meantime, she's walking back and forth in and out of her room where her mom's located. She's walking back and forth. She's sending messages to multiple other friends. And Thad is messaging her, but he can't get a response. And he says, "I'm worried about you. If I don't hear from you, I'm going to call 911. And she says, "You can't do that." Why? Why can't you call 911? Because she knows what she did was wrong. And she doesn't want 911 over there because she's about to try to kill Heath. And she doesn't want 911 over there because it's going to ruin her plan. Right? Knowing the difference between right and wrong. And you heard me, I very specifically asked Dr. Clark, you render the opinion that she could not appreciate the difference between right and wrong. Right? Well, you heard Dr. Pickett and Dr. Gugliano testify yesterday. That's not the standard in Mississippi. In fact, there's an instruction in here that defines, it's jury instruction number 10, that defines exactly what insanity is. And it goes on down there, and it says that the accused was laboring under such defective reason from disease of mind as to not know the nature and quality of the act she was doing, or 2, if she did know the nature and quality of the act she was doing, she did not know what she was doing was wrong. It's not appreciate. The standard in Mississippi is not that you appreciate the difference between right and wrong. She knew what she was doing was wrong. Look at all of her actions. Sneaking around the house. Calling over the friends. Knowing not to tell the friends over the phone what she did. SK that they called in yesterday, her friend. What does she say? Dr. Pickett talked about it. Well, she says, "I'll tell you tomorrow if I see you." Well, why would I not see you tomorrow? Well, because I'm going to be in jail probably. Right? She knew what she did was wrong. She tells her friend, Brooke, whenever Brooke comes over, She says, I put 3 in my mom, and I've got 3 more in here for Heath whenever he gets home. Right? I'm going to take care of him. 3 more what? 3 more bullets in the gun. She texted her friend, Bennett, tried to call him, did call him, text him, and he tells her, of course, again, he's a good friend too. He's worried about her. Same one that told her mom what had been going on, that he was worried about her. Trying to do the right thing. He tells her, don't hurt yourself or anyone else. Don't harm yourself or anyone else. What does she say? Too late. Again, knowing the difference between right and wrong. You saw the video from Deputy Shack, and they want you to believe that he did something wrong because he muted his body cam or whatever he did. He told you that whenever he got Carly out of the back of his car and the other deputy started performing the GSR test on Carly's hands, which you saw them doing there, being as nice as all get out to her, right? Baby, are you okay? You heard him say that his involvement in the case was over. He never went in the house. He didn't transport her to jail or anywhere else. They want you to believe that him muting the body cam was him doing something wrong. He told you that his involvement was done and over at that time. Now, I want to play just a short clip of the video for you before my time's up.
He's doing 20 minutes, which means the lady prosecutor is going to do the closing at the end after the defense.
Any further time will be deducted from the back.
Thank you, Your Honor. Ladies and gentlemen, there's no doubt that Carly Madison Gregg is the one who killed her mom, Ashley Smiley. There's no doubt that she attempted to kill Heath Smiley when she aimed the gun right at his head and shot and hit him in the shoulder. And there's no doubt that she's the one who hid the camera thus tampering with evidence in the refrigerator. And we would ask you that you go back there and you find her guilty of all three, because she was not insane at the time that this happened. She knew exactly what she was doing, and she knew the difference between right and wrong.
State went
on the back end, so it'll be 18.5 minutes.
He went 21.5 minutes. He was only supposed to go 20. That takes time away from their closing.
All right, closing by the defense.
Defense gets 40 minutes. They're going to split it up 20 minutes each. Judge is going to give them a 2-minute warning as well, like they did here.
May we begin?
Yes, sir.
Good morning. I know it's been a long week for all of you guys, and I know you're tired of coming here every day, but I want to take a minute and talk about why the state has the burden of proof that they have, the highest burden of proof that our law allows, which is beyond a reasonable doubt. A lot of people think that having that high of a burden is there because it's supposed to protect the defendants in criminal cases. But in fact, I think it protects the jurors just the same, if not more, than it does the defendant, because making the state prove every element of their case beyond a reasonable doubt is what is going to keep each of you from waking up in the middle of the night.
She can't go there. She can't go there. That was so wrong.
The decisions that you make today will not just affect Carly Gregg, it will affect her entire family. And it's a heavy burden to carry. So I want to take a few minutes and talk about the truth. The truth is rarely pure and never simple. It's what Oscar Wilde said. Let's talk about what is undisputed in this case. It is undisputed that Carly loved her mom. You never heard the testimony of one person in this case who said otherwise. It's undisputed that Carly had no history of violence prior to March 19th. Nothing you heard. There is no evidence that tells you otherwise. It's undisputed that Carly Gregg loved her stepdad. In fact, he was the only dad she really ever had. No one told you otherwise. It's undisputed that Carly Gregg believed her father had a mental illness, bipolar disorder, and schizophrenia. Carly was afraid of her dad. She knew he was an unsuccessful man. She knew he was abusive. She didn't like being around him. She didn't want to be like him. It's also undisputed that that's something Carly worried about all the time, because that's something her mom worried about all the time. Her mom frequently worried that Carly was going to end up with the same mental illnesses that her dad had, because they're hereditary. It is undisputed that Carly had been experiencing serious mental health issues for quite some time prior to the events of March 19th. She had bulimia for 2 years. She had intrusive thoughts. She had racing thoughts. She had engaged in self-harm behaviors. Carly had anxiety. She had been diagnosed with a major depressive disorder, and she had developed trouble sleeping for months prior to March 19th. Moreover, we have her journal entry from April 7th of 2023, in which she writes down, "Do I have schizophrenia?" We have Carly's other journal entries prior to March 19th, including her journal entry on March 12th, which you'll have back there in there with you, and I implore you to read, in which Carly writes down and says, "Am I having a psychotic break?" Talking about the voices in her head. We heard the testimony of SK, and that testimony came out on cross-examination, not with me on direct, but with the prosecutor on cross, that yes, Carly did in fact tell somebody prior to March 19th that she'd been hearing voices in her head. And who did she tell? The person she was most likely to tell, her very best friend, who told us that they told each other everything. Now, it is also undisputed that Carly's mental health issues worsened by December of 2023 to the point that her parents sought medical intervention and put her in counseling and got her on an antidepressant. And I want to take a minute and break that decision down, because we've spent a lot of time in this case talking about Carly and her mom and how much they loved each other. But I want to break down the decision a mom is making to put her child on an antidepressant at that point. What did we know about Ashley Smiley? That she was an incredibly loving mother. Her world revolved around Carly. What Michael just told you was true. Carly was the love of her mother's life. We also know that Carly's mom was overprotective, and understandably so, because she had lost a child. Carly was the only child she had left. Do you honestly believe that loving, overprotective mother would make a decision to put her child on an antidepressant medication when she herself had had horrible side effects when placed on Prozac? She'd become suicidal. Do you think that mother would have taken any risk with her child, the only child she had left, knowing how serious those risks were, when she decided to put her 14-year-old on an antidepressant medication? No, of course she wouldn't. That tells you everything you need to know about the serious issues Carly was having, whether her parents wanted to admit it, whether Carly wanted to admit it or not. You can't tell me Ashley Smiley, as loving and protective as she was, would have taken that risk with Carly if it wasn't required. Now, knowing all this, it's also undisputed by Rebecca Kirk, the only medical professional who spent more than a day with Carly that you heard from in this case, who had treated Carly from January of 2024 to March of 2024, a 3-month period of time, that Carly was a sweet, gifted child with no history of violence. Ms. Kirk also called the taking the knife to school incident much ado about nothing. She told us that it was evident that Carly loved her mom, wanted to please her mom, and was worried about stressing her mom out, to the point that Carly walked on eggshells, trying not to upset her mom. She told us a story about how at one point Carly saw her mom having to grade a bunch of tests, being stressed out, and Carly wanted to help. So she asked her mom if she could help her grade the test. And when Ashley snapped back, which is something parents sometimes do when they're stressed out and a child catches you at the wrong moment, that hurt Carly's feelings so much, that was the only thing that Rebecca Kirk could pull out of her when she was trying to get Carly to open up about traumatic experiences she had had. Just having a mom snap at you was traumatic to Carly. How could Carly tell her mom she was experiencing the same mental health issues that her dad had? How could any 14-year-old? It's also undisputed from Ms. Kirk herself that she knew there was more going on with Carly than Carly was disclosing. And she worked very hard at that last session trying to pull it out of Carly, to the point that she thought, maybe I should refer them to somebody else because there's more here than I can get to. We've heard the testimony of Carly's stepfather, who has no reason to defend this child. It's not his biological child. He was very much in love with his wife. They were still in the honeymoon phase. You heard him on that 911 call. That was a man in shock, in grief, and in pain. You heard his testimony about feeling intimidated regarding his testimony in this case. But despite all of that, he has continued to tell the truth consistently from March 19th until his testimony in this courtroom today, and he continues to stand by Carly to this day and support her. And he said, yeah, I've noticed that Carly was experiencing memory lapses in the fall of 2023. It was bizarre. I noticed that Carly was losing track of time. It was bizarre. They knew Carly wasn't able to sleep. They were worried about how much melatonin she was taking to try to sleep at night. We heard from Dr. Pickett how that all correlates with bipolar disorder. It is undisputed from the testimony of the minors who testified in this courtroom this week, that Carly had only started smoking marijuana in February. It is also undisputed by the testimony in this case and the records we put in evidence from Vital Corps, which you'll have back there with you, and I hope you'll look at, that it was only after Carly was finally put on Abilify, an antipsychotic medication, that the voices stopped and her mental health issues decreased. The crying spells, the depression, the low lows. Only after the antipsychotic medication. And why? Well, we heard from the medical professionals why. In the words of Dr. Clark, when you have a child experiencing psychotic issues, you have to stabilize their mood before an antidepressant can be effective. And if you don't stabilize their mood, then the antidepressant can do more harm than good. And that's exactly what happened to Carly Gregg on March 19th. We heard the video from the garage cam of Heath Smiley coming home on March 19th. We heard those feral screams that Carly made the whole time. And we heard the testimony of Mr. Smiley that he was so convinced by the state of terror Carly was in that after she left that house and he was wounded and bleeding, he walked around the house with the handgun looking for the intruder that he believed was there based on the state of terror Carly was in. We heard the screams. You can't fake that. You can't make that terror up. Carly has consistently reported to everyone that the last thing she remembered on March 19th was taking the dogs out, and the next thing she remembered was crawling through a sewer filled with water. And I personally believe that it was the cold water that brought Carly back out of it and back to herself, the shock of it. The state would have you believe that Carly intended to kill her mom on March 19th when Carly didn't even know during the evaluations that her friends had sought to intervene because they believed that what they saw from Carly was due to marijuana use that started in February rather than symptoms of a mental illness that they could not know about. But that story just doesn't track. Because for the genius kid that Carly has been repeatedly described as, don't you think she would have known if she intended to do what she did on March 19th, where the camera was in the kitchen, and that she ought to take it down before it films her doing everything she did? Because I didn't make a 30 on my ACT, but I would have known to do that. That doesn't sound like the actions of a smart kid who was intending to do anything. If Carly intended to kill her mom because her mom found out she was smoking pot, then why wouldn't she have left the house after she killed her mom? Why not run then? Why call all of her good friends asking for help, terrified, crying, saying she couldn't tell them what happened? Why text her stepdad anything? Why wait in the house? And what did her stepdad have to do with anything? He didn't know about the marijuana usage. He didn't have any skin in that game. It doesn't make sense. And the state can't tell you why she did any of those things. But they have to prove it to you beyond a reasonable doubt. Now, no one, not her stepdad, not her counselors, not Dr. Clark, who was teaching psychiatry at Harvard while Dr. Pickett was still in medical school, believed that Carly was a sociopath or a psychopath. Even Dr. Pickett said that was going too far. The state put on the testimony of BW, who is the only person who told us anything about Carly making a statement about shooting her mom, and she had 3 more for her stepdad. I didn't hear that statement from the law enforcement officers that interviewed her. I heard it from the prosecutor. But I also heard from the prosecutor that BW was a little bit of an unreliable witness, because she answered the first question of, where did Carly get marijuana from? I don't know. To have to answer immediately with the follow-up question, well, isn't it true that you bought it and gave it to her? Yeah, that's true. So that tells us right there, we've got a little bit of an unreliable witness. Now, we also had Dr. Pickett, who gave us his opinion. But Dr. Pickett admitted that he had no experience whatsoever in the field of child and adolescent psychiatry. He had never evaluated a child before Carly. He had never testified in a criminal case before, and he had never qualified as an expert before in anything, in any criminal case before this one. So I have a hard time accepting Dr. Pickett's opinion that, especially when he is discounting the diagnosis of a doctor who diagnosed Carly's father with bipolar disorder, and the reason that Dr. Pickett told us that he discounted this other doctor's diagnosis was because that doctor had only seen Kevin Gregg 3 times. Well, Dr. Pickett saw him 0 times, but yet he's able to undiagnose him and re-diagnose him? I mean, if Dr. Pickett can diagnose or undiagnose someone without ever seeing them, he's going to have a hell of a career. And even though Dr. Pickett denied having a preconceived bias going into this case, I couldn't help but realize he had memorized all the medication that Kevin Gregg was on that he believed contributed to Kevin Gregg just being a drug addict. But he somehow missed the 3 antipsychotic medications that Kevin Gregg had been on. That Mr. Gregg had been prescribed for his bipolar disorder and possibly schizophrenia. But you know what? Those facts didn't fit his story, so no need to include them. And I actually couldn't stop thinking about that. Why was it that he memorized the medications he believed were easy for people to abuse and become addicted to, but just couldn't remember at all the 3 antipsychotic medications that Mr. Gregg was on at the same time? That stood out.
She just said that.
To me, who's not a doctor and who doesn't have training in this field. I had to go Google those drugs to learn they were antipsychotics. And then I realized when I was looking at Dr. Pickett's CV, which we also put into evidence, and I hope you look at, that he served as a Hinds County Sheriff's deputy for 3 years prior to going to medical school. And it made sense. Then his diagnosis made sense to me, because when you're a hammer, everything looks like a nail.
2 minutes, ma'am.
Wow.
I hope that seeing all the people who knew and loved Carly the best prior to March 19th, her friends, her maternal grandparents, her stepfather, her counselor, I hope seeing that they still love and support Carly Gregg after March 19th tells you everything you need to know about the incident that occurred on March 19th, that wasn't Carly. Because if it was, why would the parents of those friends still let their daughter call Carly? Why would they be here testifying for her? And let's talk about this genius kid. The easiest story she could have told would have been, I shot my mom and stepdad because my stepdad had been molesting me for years. My mom knew about it and said nothing. And people would have bought it all day long. That's a convenient lie. And it would have served her all day long at the expense of her mom and her stepdad. That's the easier story to tell. But that's not what Carly said. Carly told the hard truth about her mental health issues. A truth that these are rare and it's happening, but that this happens often when you put kids on the wrong medication, when they already have these underlying significant mental health disorders and they get treated with the wrong medication. This is what can happen. I hope none of us are ever judged by the worst moments of our life, but rather by our lives as a whole.
She has 30 seconds left.
And I think when you step back and you look at the facts of this case as a whole, okay. And when you look at the facts of this case as a whole and the picture of who Carly Gregg is as a person on a whole, you will see that this was not a bad kid. This was not a kid who was enraged. This was not a kid who had hatred in her heart for her mother or her stepfather. In fact, the exact opposite. This was a kid who was experiencing significant mental health issues, the same mental health issues that ran in her family and that we know are hereditary. This is the kid who was compliant with the medication she was put on. However, that medication, without anyone being able to tell beforehand, caused her symptoms to worsen. And while she was having a state of psychosis and an episode of acute stress on March 19th, she lost herself in what was the perfect storm. I am asking you, for those reasons, to please find Carly Gregg not guilty by reason of insanity and finally quell this storm for Carly and her family. No one will understand this case, and no one has heard this case the way that you have. And passing judgment on another person is a heavy burden to bear, and I'm sorry that it falls on you. But please consider what is at stake in this case for this child and this family. Before you rush to judgment and render your verdict, look at those documents, consider the testimony. Search your heart for what you know about this child from the picture painted by her of all the people that knew her best. And you tell me, what was the intent? You tell me why someone who intended and had planned to murder someone wouldn't have taken the camera she knew was in the kitchen and was easy to see down before she did anything, especially when she was a genius. I mean, that's not the actions of a diabolical, evil genius, leaving camera footage up for everyone to see, crawling through a sewer instead of just running away, calling friends for help, friends who could later testify about what happened.
She's not stopping. She's gone 2:30 over.
Again, I ask you to search your hearts and remember the undisputed truths in this case. Thank you.
2:45. Deduct. Or two.
Mr. Camp, 17 minutes.
Thank you. So it took 3
We'll
minutes.
start the clock until you have everything set up and you're ready.
They did start the clock earlier before, because I started the stopwatch as well. They started the clock as soon as the defense lady got up. So now they're being a little more generous. Now we have 17 minutes for Mr. Camp to finish. Then we'll go back to the state for another 18 and a half minutes for closing. So we'll hear from all four attorneys, prosecutors and attorneys.
I'm good, Your Honor.
There we go. 17
May it please the court?
Yes.
Okay, we've been doing this since Monday, so I know y'all are probably as tired as I am. This was always going to be a very difficult case, and it's going to be difficult because the issues that we're dealing with is difficult because we're in part of a realm of the law and everything where you've been hearing a case all week and the defendant has basically said she's guilty. And so there's not an issue of guilt in this case. As we said from the get-go, this is not a who did it case. This is why it happened. Okay, what's going on? That's what you have to make the determinations is what's going on in Carly's mind as all this stuff is happening. And that's the difficult part, because you don't get to just look at the video and say, she did it, because that's, most cases, that's what you're doing. And it's an easy decision because you're looking at it and you simply see who did what, how they did it, and that's it. Now, in this case, because we're dealing with her mental state, we're having to get inside her mind and understand what's going on and how that's all working. And that's what this case has always been about from the get-go. It's never been about who did it. One of the things that I wanted to talk with you just a little bit about is you had, in this case, you had three psychiatrists, or excuse me, one psychologist, two psychiatrists. And both of the psychiatrists were forensic psychiatrists. And the psychologist was a forensic psychologist. And you had the two psychiatrists gave very different opinions, very different opinions. And some of the things that I wanted to point out on that is you have one of the doctors, which is Dr. Pickett. It was his first time ever being qualified as an expert, first time testifying. He just got certified a year ago. And then you have an opinion of somebody who has even a higher degree, and that's Dr. Clark. And Dr. Clark is board certified in pediatric and adolescent psychiatry, which means he deals with kids. He deals with teenagers. He knows the nuances of how that works. If you listen to Dr. Pickett, and Dr. Pickett was 100% correct on this, he can do evaluations on everybody. But the problem is he doesn't know the nuances of the kids and the adolescents. And we're dealing with an adolescent. Carla was 14 when this happened. She turned 15 in jail. As all of y'all know, things are changing in people's bodies at those ages. They're growing, they're becoming adults. You have a lot of different things going on. All those things have to be taken into consideration when you're coming up with the decisions, or when you're coming up with how to do an evaluation on a person. And that's why you need that specialized knowledge, is to know what's going on in teenagers. Dr. Clark gave you a very precise reason of how all this happened, why it happened. And he said it was a difficult case to look at. Dr. Pickett, he basically wanted to just pick Dr. Clark's case or diagnosis apart and say, couldn't happen. And one of the big issues with that was the diagnosis of Carly's father. And why that's important is one of the prongs, and I know you've heard psychiatric stuff all week and it sort of gets old, but one of the prongs in order to see if somebody, I guess, is bipolar, one of the big issues is, has that person, or does that person have a family history? And that's why that became a big issue. And you heard Dr. Pickett get up there and he looked at Dr. Hardy's stuff and said, well, I'm going to change the diagnosis. So he said, I'm going to discount that, which takes one of the prongs away with one of the things you're looking at with Carly. The other stuff that he wanted to discount, and I thought this was interesting, is you just heard, you're reminded about SJ or SK when she got up on the stand. And she said, yeah, Carly had been hearing voices. I knew about it. Carly said that. Dr. Pickett, you heard him on the stand. It's like, if you bring me credible evidence, you bring me something, I'll change my mind. Well, you had the friend say, oh yeah, I mean, we talked about it. Comes out on cross-examination, not direct, which was interesting. But it comes out, and then Dr. Pickett sits there and says, well, that's a friend, so I'm not going to count that. Okay, there's a journal. Okay, in the journal, Carly makes some notes about that she's heard voices and stuff. I'm going to discount that because I think that's her embellishing. All this stuff is all the SJ's testimony, the journal, all that stuff's happened before this situation took place on the 19th of March. And it's important because what you're seeing, and it's what Dr. Clark said, there's probably an undiagnosed, or there was an undiagnosed situation going on. It happens for a lot of different reasons. You have an individual, Carly, who's not telling everything. We know that. We know a lot more now than we did before. You heard from Miss Kirk, and I thought Miss Kirk was one of the things that was very enlightening with what Miss Kirk said, was she was having a difficult time getting anything out of Carly. She really wasn't opening up. And so finally, the last session, which happens to be right before this happens, she was able to open up a little bit with her and get some more information. And in Carly's journal, there's an entry in there that talks about she likes Miss Kirk and that she may bring her the journal and let her see some of the stuff. That was something that was interesting. The other part that Miss Kirk said, she had no idea. Nobody had any ideas that this was going to happen, that there was a chance that this could happen. There were no clues. There was nothing. This is one thing I do agree 100% with Dr. Pickett on, and he said this was an unusual case. And the reason why it's such an unusual case, daughters don't go and shoot their mothers for no reason. Dr. Clark talked to you a little bit about it. It's like, well, usually you either have panic, and we saw from the video and everything, there's no panic. He also talked to you about that there was mental issues that were going on. They had started in January. She was getting treatment. We didn't know how bad they were, but she had started getting treatment. They were getting worse, as we can tell from different things now, where we're looking in the journals and things of that nature. The other thing that's very interesting is that on the back end, once she was incarcerated and she was getting treatment, the correct treatment, she got better. And that's when she got the Celexa and the Abilify. And those medications were working. And it's sort of what you were just told a second ago. You have to have a stabilizer. And that's what she needed, was the stabilizer. It stopped the voices. It stopped what was going on. We go back to the 19th of March, and you see what occurred. There's no reason why Carly should have gone and shot her mother. There's no reason. What equally weird about this whole situation, and it was in the state's opening, they talked a little bit about it. She crossed her arms. Again, very bizarre activity. She's singing to the dogs. And the most bizarre thing that occurs is this. She wants to go after Heath. Why? There is no reason. She calls her friends over. Friends are fine. If she's some sort of psychopath wanting to go shoot 500 people kind of person, if she's calling people over, those would be some of the people that she would, I guess, target. But no, what happens is she's reaching out for help. She's in a mental health crisis. You heard the video that, or the audio, I guess, of Heath when Heath was when he arrived home, opens the door, and gets shot at. Heath took the stand. He tells you to this day that wasn't Carly. The person that was shooting at him was not Carly. It's real important. He's the last person that's seeing her right there as it's happening. This is the person who knows. This is the person that sees her every day, that knows Carly. And yet he's saying she's shooting at him. If there's anybody that has a reason to, disavow Carly and say, hey, look, she shot me. I don't want to have anything to do. She killed my wife. He's sitting there saying, and he was doing it to his own detriment. And he's saying, that's not her. Something's wrong. That was not her. And that's what he was trying to convey to you. Now, the next thing we have, can I play the video real quick? Will you help me with that? We have the video from Hinds County Sheriff Officer or Deputy Chat. And we played it. And if you remember, the last thing that he says before, I guess it would help if you have the last thing, and we put it to, move it up a little bit. The last thing that he says before he mutes his body cam. Listen to what it is. He says something to the effect that she doesn't know about her mother. And before we go back and listen, remember what Shaq said.
Shaq?
Why he was muting.
Oh, I thought you were talking
He
about
said
Shaquille.
it was a personnel issue. If she doesn't know about her mother, that she is shot, and all this stuff that's gone on, she doesn't know what's going on. That's why that's important. And I want you to listen to it. You're going to be able to take this back and see and hear this video again. There's a policy.
It's only got 2.5 minutes
and
left.
I put the policy in evidence, just so everybody's clear. They cannot do what Shaq did. They cannot mute it. They don't have, yeah, you can go ahead. We're going to watch it. How much?
It needs to fast forward.
Go ahead and stop it. I'm running out of time, so y'all will have to look at it. But this is, when you go back in the jury room,
it's got 2 minutes left.
You have some decisions to make. And these are the decisions that you have to address. You can find her guilty. You can find her not guilty. And if you find her not guilty, you have two different options. It says not guilty by reason of insanity. And then you have to see if she has been restored to reason. If she has, then she's finished at this court.
She walks free.
The other option, and this is what you have to look at.
That's what they're going for.
Is
the second one.
You can find her not guilty by reason of insanity, and that she has not been restored, and that she's a danger to the community. And what that means is she goes to the state hospital or somebody comes, so she gets evaluated, and they make the decisions on what happens to her. So when I'm telling you this is not, she has the keys and she's walking home. That's not what happens. We believe from all the testimony, and you can look on it here, you have the father saying it's not her, and then you have Shaq saying she doesn't know what happened. When you see those, that tells you she doesn't know what was going on at that time. We're asking you to find her not guilty by reason of insanity. And then you have to make the decision, was she restored or was she not? If she's not, she gets evaluated by the state hospital. They determine what's going to happen to her.
15 seconds.
That's what we're asking for. We want you to find her not guilty by reason of insanity.
He'll reserve his last 7 seconds. Now it goes back to the state for, let's see, 17 and a half minutes.
State.
Or
18 and a half minutes. We won't start the clock until you get everything set up.
Just a minute. I have some of your exhibits here.
Oh, we
If you would
didn't hear
just
from
turn
her.
them up here to the exhibit table, please, sir.
We get her again.
Yes, sir. Restroom break? All right.
I love that.
All right. If y'all don't mind, we'll sort those out in a moment. If y'all have a seat for just a second, we'll sort out the exhibits. One of the jurors has indicated they need the restroom. We're going to take a brief restroom break, all right? Everyone remain seated while the jury exits. Y'all just knock and let us know when you're ready, okay?
Never seen that red stitching on a buttonhole on a suit like that. It's interesting. I guess I don't have current fashion trends in my suit choice. Okay, well, the jury leaves. I think as we take a break, I'm going to go over just a couple things. This is probably going to be a very short break, 5 to 10 minutes at most. I assume they're gone. There we go.
Correct. All right, record reflect we're outside the presence of the jury. Juror need a restroom break. We're in recess till they knock on the door. Not a minute longer. All right.
All right. As the jury goes to break and everyone drinks their cherry Coke, couple things the jury has to decide. We heard from the jury instructions today. There are 3 charges she's facing. She's facing first-degree murder. She's facing attempted murder. She's facing intentionally, I think if we just use the part that's applicable in this case, intentionally moving or altering physical evidence of a crime. Those 3 charges the state has addressed. We talked about the elements of the charges. I think the last one is pretty self-explanatory. Intentionally moving, that's when she moved the camera. There is a presumption that she is sane. That is a legal presumption. The fact that you're walking into a court, the presumption is that you're sane. The defense has raised, and I think to a reasonable level, appropriately, the possibility, to a reasonable doubt, that she isn't sane. So they've presented that. Once they raise that, that's their duty first to get to that point. Once they raise to that point, the burden switch over to the prosecution, and the prosecution then has to say, now we will prove that she is sane going forward. And this is different than the examination beforehand, seeing if you're mentally competent to stand trial. That this is a separate thing. So in this, they're proving that at the time of the crime, this is one of the elements, because insanity in Mississippi, it's defined as at the time of the crime, the accused did not know the nature and the quality of what they were doing. Or alternatively, if they did know the nature of the crime of what they were doing, they did not know that what they were doing was wrong. So the state has to get past those 2 points, and that's a pretty low threshold, and they've got some strong evidence to show that she did, at the time of the crime, know what she was doing was wrong. The hiding the gun, it would be strong evidence to show she knows that this should not be seen, that she should not be doing this. The gun's behind her, and they presented all that. That was pretty strong. But basically, if the jury believes that beyond reasonable doubt that on March 19th that her actions were willful and feloniously without authority of law took the life of Ashley Smiley, then it's guilty. If they do go with not guilty, those two options you heard, not guilty by reason of insanity, that you say, okay, she's not guilty at the time by reason of insanity, there still leaves you two more choices for the jury. First of all, you can say she's not guilty and she's still crazy, which means that routes her to the state mental institution where she can be held as long as needed to restore her to sanity. And once she reaches sanity, she's released to the public. Or you can say she's not guilty, but now she's sane, which would be in effect saying she's not guilty because she was insane at the moment, but she's not now, so she's not guilty. She walks free from the courtroom. I mean, they'll take her back to jail and give her her day clothes that she checked in at, and then she goes free today. So those are the two options. I think the defense is leaning towards go to the middle road. Choose not guilty, but she's still insane, which is a weird thing. It's an easier decision for the jury to make because she still gets locked up, just in a state hospital, and she gets treatment. It's easier to mentally make that adjustment than to what the defense lawyer wrongfully raised at the beginning of her statement. Actually, let's go back and listen to that really quickly. Goes like this.
And talk about why the state has the burden of proof that they have.
Hang on one second. That's my timer. I need that timer to go away. Hold tight. Wrong mouse. That's going to be our jury deliberation timer. We're just getting things ready, but it was on the same computer. So playback. Okay, I might have to do this sort of a weird way here. Nope, I need it on full screen.
Have the highest burden of proof that our law allows, which is beyond a reasonable doubt. A lot of people think that having that high of a burden is there because it's supposed to protect the defendants in criminal cases. But in fact, I think it protects the jurors just the same, if not more, than it does the defendant, because making the state prove every element of their case beyond a reasonable doubt is what is going to keep each of you from waking up in the middle of the night.
Objection. Sustained. That was so quick. That objection. She wanted to say waking up in the middle of the night thinking, did I do the right thing? You're not allowed to pull the jury in and say, this will haunt you for the rest of your lives. You're not allowed to do that. And she did. She went there. And if you listen carefully, she sort of hinted at it again a few minutes later without making it direct. She sort of talked about Carly. She's like, that's why it's such a heavy burden. And then at the end of her statement as well, she went there one more time and sort of hinted at it as well. So anyway, that was bad. That was very bad. Every lawyer, I think, knows that the pass of the bar knows you're not supposed to do that, but she did. Can you fault her for trying to think about the jury? Yes. Yes, because it's impermissible. It's like saying, hey, can you fault an Olympic athlete for doping because they want to win? Yeah, you can. You can't do that. You can't do that. The jury's not supposed to make decisions based on, well, how will I feel about this after when I read about it in the newspaper next week? And yeah, that's not okay. That's not okay. They have to make decisions based on the facts and the evidence that's in court. All right, as we wait for court to come back here, we've got just a minute. Facts, not emotions, for sure. Chad Daybell's house is being demolished. I saw a link to that being sent to me. Thank you very much. It's going to be completely gone. I believe somebody bought that as to make it a memorial, and they're destroying the house. They're going to make a memorial for the kids. They are live streaming it. I can't necessarily show the live stream here. But.
All right, jury's not ready yet, but for everybody in the audience, once they are, you don't need to be tossed, not when the jury comes in.
Hang on.
Y'all are free to talk now, just not when the jury comes in. Set up.
Yes, sir.
Let me see if I can sync up our video and audio here. We've got a mismatch.
Getting a good look at.
Yep, we are. I'm getting a great look at the audience. Okay. Just a second here. Who's next to the grandparents? I don't know. We've got lots of family there. I believe the lady who's sitting down with the earrings and the denim jacket, I believe that is Ashley's mom, I believe.
Author in this.
While the jury enters. Bring them in.
They're bringing the jury in. Just 1 second here. Trying to listen to all the different commentary from everybody. It's confusing, but this is how I work in my head. I listen to like 6 things at once. And I read chat. I hear voices. Yes, that's basically what I'm saying. I've got it on the record right now. I hear voices. And you heard a couple of them. I don't see the stepdad there. He is not there today. I wonder. Well, we know he supports her.
Closing by the state.
Let's start our timer.
May I proceed, John? Yes, ma'am. Let me pick up right where Mr. Kent left off, ladies and gentlemen. What he was telling you is that if you find the defendant not guilty by reason of insanity and you decide that she's been restored to competency, she'll walk out the door of this courthouse. You heard about voices. Let me tell you whose voice I'm talking about today. Ashley Smiley. Ashley Smiley's voice matters. Because of Carly Gregg's actions, we will never hear Ashley Gregg's voice again. Ladies and gentlemen, you heard the very last noise she made. Carly Gregg, her daughter, took a gun, walked across the house, pulled it out on her mother, fired once, you hear her mother scream. Fired twice, you hear her mother scream.
She's holding the 357.
3, 4, you hear the third shot, ladies and gentlemen. You saw that awful picture. You saw the stippling. You saw what she did. That person has not been restored. That person was never insane to begin with. You know what you didn't hear the defense attorneys talk about? The insanity standard. You know why you don't want to talk about the standard? Because they can't prove it. They can't prove it, ladies and gentlemen. You know what they tried to stand up here and say? The state hasn't told you why. Ladies and gentlemen, when we talk during voir dire, what do we talk about? That's not the state's burden. You won't find one place in the jury instructions that it tells you that the state of Mississippi has the burden to show you why Carly Gregg killed her mother, to show you why Carly Gregg attempted to kill Heath Smiley, to show you why Carly Gregg removed that camera that caught her actions and hid it into the refrigerator. That's not our burden. Our burden is to show beyond a reasonable doubt that she did it. And the defense attorneys have admitted that she did it. Let's talk about who needed help. Miss Todd wanted to talk about Miss Gregg needed help. Ladies and gentlemen, I submit to you that the two people that were begging for help was Ashley Smiley and Heath Smiley. We heard the 911 call. He says, oh my God, she's killed her mother and she tried to kill me. He says on there, please help. Send me help. He tried to say that, oh, now maybe Carly didn't mean to kill me. Ladies and gentlemen, I don't know why he's saying that, but I know that she shot him 6 inches from his head. And I know that she told Brooke Wafer, her friend, that I put 3 in my mom and I got 3 more waiting for my stepdad. You think that sounds like an insane person? No. That's a person that knew this gun right here, this .357 Magnum, had 7 rounds. That's a person that knew that she'd put 3 of them in her mama's head. She had 3 more waiting for Heath, and who knows what she was doing with the last one. The why doesn't matter. They want to talk about the doctors. Dr. Pickett this, Dr. Clark that. Y'all heard him. Dr. Pickett said, yes, this is the first time I've had to testify in a criminal trial. But I have evaluated over 100 people for competency and sanity. You heard from Dr. Gugliano when she took the witness stand that she's done hundreds, if not more, evaluations of sanity and competency. Let me tell you what you heard from Dr. Clark. When the defense went to tender him as a forensic psychiatrist, he said, no, that's not what I am. I'm a child and adolescent psychiatrist. Did he render any opinions specific to children? No. Does his diagnosis of Carly Gregg matter? No. When you look at the standard in the state of Mississippi to be able to prove insanity, all right, she has a mental illness, right? I think we can all agree that those records state that from the time she was a small girl until we sit here today, that she has anxiety and depression. Ladies and gentlemen, it is undisputed that anxiety and depression do not cause someone to commit murder. It is undisputed in this courtroom that Kevin Gregg, if you believe his diagnoses, if you believe he was bipolar, schizophrenic, drug addict, all of it, does any of it matter? No, because you know what he didn't do? He didn't kill his parents. Ladies and gentlemen, the diagnosis doesn't matter. You heard, and I made notes of it. When Dr. Clark was testifying, Michael Smith was asking him, did she know right from wrong? That's what we got to know. Did she know right from wrong? He says, well, she knew something about what happened. Okay, well, she knew. Then he goes further and he said there was some level of awareness about what she was doing. Let's talk about that, ladies and gentlemen. She knew where she was. She knew who to call. She knew her mom's passcode. She knew where the loaded weapon was. You have pictures and evidence. There were other guns at the house. She didn't go pick up that unloaded shotgun and take it in there to where mama was. No. She went in there with that .357 Magnum that she knew was fully loaded. She knew to text her friends. She knew to FaceTime her friends. She called them by the right name. She called them by their nicknames. She said, I fucked up. She said, don't call 911. You know why, ladies and gentlemen? She wasn't done with her plan. We don't have to prove why she wanted to kill Heath Smiley. All we know is she did. All we know is that after she killed her mom at 4:14 in the afternoon, she lied in wait, sent a message to her stepdad saying, hey, honey, when will you be home? She knew not to do it from her phone. She did it from mom's phone. When will you be home? Because I'm waiting for you. Sends him a thumbs up. Then when he comes in the door, what's she do? Points the gun at his head, ladies and gentlemen. She knew exactly what she wanted to do. And then when she wasn't sure if she was successful, she ran. Insane people do not run because they don't know right from wrong. Insane people do not tell people, I need help, because they don't think they've done anything wrong. Insane people do not flee the scene. Again, they do not know right from wrong. Carly Gregg knew everything she was doing that day. What Dr. Clark said from the witness stand is that he wants you to put all your common sense aside. There's a whole stack of medical records. He says, I didn't really pay much attention to the medical records. Not any of those other providers that actually treated Carly that said there was no mention of voices. There was no mention of lapses in time, these disassociations. But you know what I'm going to rely on? Oh, wait, no, I also didn't look at the text messages. I didn't think it was important to know what the defendant was doing at the time of the crime and between when she killed her mom and when she attempted to kill her dad. That wasn't that important. You know what's important? What the defendant said after she's been arrested for violent crimes. That's what he relied on, ladies and gentlemen. He said, well, Carly said that there were voices before. Pretty convenient, right? We talked in voir dire on Monday about why do people lie? Why do people lie? Protection. Dr. Clark said on the stand, Lexapro doesn't cause murder. Lexapro might cause people to be more prone to suicide. Lexapro does not cause people to murder. Dr. Clark said on the stand that disassociation, that's what Carly had, right? That's what he diagnosed her with. But he couldn't say that disassociation causes people to commit murders. In fact, what he said was that people tend to disassociate when they are experiencing trauma. Let's think about that. Common sense tells you if someone's in a disassociated state, they don't know what's going on, it's because they are on the receiving end of the violence. They're sex trafficking victims. They're prisoners of war. They're not children that are mad at their parents because they found out about their secret life. He expects us to believe that we can take the word of the defendant who has never reported, even to Rebecca Kirk, who she said she loved and trusted. She never reported voices to Rebecca Kirk. She never reported these lapses in time. In fact, you didn't hear that from any provider that's ever seen Carly. Let's take another step. Then Carly doesn't stop there, ladies and gentlemen. She tells Dr. Pickett, oh yeah, I was still having one of these moments. So let's talk about she's safe. Heck no, ladies and gentlemen. She's claiming that she's still having those moments while she's in our courtroom. During one of our hearings, she's saying she was in one of these disassociated spells. During her evaluation with Dr. Clark, she reported that she was having one of these disassociated spells. During her evaluation with Dr. Pickett, she was claiming she was having a disassociated spell. But you know what? She remembered every bit of it. I find it interesting that she told Dr. Clark that she has nightmares. She hears gunshots. You don't hear gunshots if you don't remember them. You don't have PTSD from an event that you don't recall. She told Dr. Gugliano that she gets queasy. She gets sick to her stomach when she thinks about what happened that night. I would too. Ladies and gentlemen, unfortunately, we've seen the pictures. We know what she did. That's not the face of someone who's insane. We don't have to prove the why. When Dr. Gugliano asked her, Carly, what's bothering you the most right now? She said, I always ask patients that when I'm evaluating them. Carly said, I'm missing school. Think about that. Not, I miss my mom. I'm so sorry that I did this. Oh, I hate what I've done to my family. I'm missing school. I asked Bennett Germany when he took the stand, you and Carly are still great friends, right? He said, best friends. Y'all talk all the time? Yeah, all the time, even now that she's in jail. I said, Bennett, on any of your calls, any call, has Carly expressed remorse for what she has done? He took that stand and he said no. I want to talk about Bennett too. He said, while I was asking him a question at some point, he said, I'm sorry, can you repeat the question? I zoned out. Ladies and gentlemen, we've all had a moment where we've zoned out. We've all had a moment where we've driven down the road and got there and thought, how did I get here? I don't remember, but I knew I drove here. I tell you, when I have those moments, I'm not insane. I know exactly how I got there because I was the one driving the car. I know right from wrong, and Carly knew right from wrong that day. There is no record, no medical record of Carly hearing voices before this. I want to talk to you about some of the things, some of Carly's actions. Let's talk about some of her willful actions. First of all, I want to show you these two. Let's not forget this. These were recovered from inside Ashley Smiley's brain and neck. Who put them there? Carly Gregg. Carly Gregg's willful actions. Let's talk about that. We talked about she knew where her house was. We talked about she knew that her mom was upset with her. She told Dr. Pickett, yeah, my mom was very upset. The defense wanted you to believe that everything was hunky-dory that day. It wasn't. We've seen the videos. She may not have been yelling, but she sure was upset. We know that Carly knew her mom's password. We know that she intentionally pulled the trigger not once, not twice, but 3 times, shot her in the head. We know that she called her friends over. We know that she told them don't call the police. We know that she wouldn't let them know what was going on. We know that she tells Brooke, right? Let's talk about the tampering with evidence. She tells Brooke when she comes in the house, one of the first things she asks is, are you queasy around dead bodies? Ladies and gentlemen, use your common sense. What does that mean? I know if I'm asking somebody that, it's because there's a dead body. She knew that she had killed her mom. She tells Brooke, I got 3 waiting for my stepdad. She knew that she was going to shoot her stepdad. She also tells Brooke something important. Oh, don't worry. I pulled the cameras down already. I pulled the cameras down. She knew enough to rip that camera off of where it was, hide it in the refrigerator. Was it a perfect plan? No. Nobody ever said her plan was perfect. That's why we're here. But ladies and gentlemen, that's not insanity. That's not insanity. I want to talk about Deputy Shack and his interaction. Mr. Camp said, oh yeah, he's saying she doesn't even know about her mother. We heard from Deputy Shack. He took the stand. He said she never asked about her mother. Ladies and gentlemen, you know the only person she asked about in her interaction with law enforcement? How's Heath? You know why? Because the only thing Carly Gregg didn't know from that day was whether or not she was successful in killing Heath Smiley. That's the only thing she didn't know. Again, the defense wanted to talk about it's the highest burden of proof. We have the highest burden of proof in criminal law. The state of Mississippi has to prove beyond a reasonable doubt that Carly Gregg intended to kill her mother and did kill her. We have done that. They don't dispute that. We have to prove that Carly Gregg intended to kill Heath Smiley and was unsuccessful. They don't dispute that. We have to prove that Carly Gregg intended to remove evidence and hide it. We've already proved that. They don't dispute that. The only thing that the defense wants you to do is to have sympathy for the defendant, to believe this story that she's made up after she's been arrested. Dr. Clark talked about that on the stand, right? He admitted that there's research out there that shows that there is a large population of people that claim disassociation after they have committed homicide. And we asked him, why? Secondary gain. What's secondary gain? So I don't get in trouble. Pretty convenient. If I don't remember what happened, I was having an out-of-body experience. Maybe they can't get on to me. Ladies and gentlemen, don't fall for that. That does not make sense. I want to talk about some of Carly's journals and some of the text messages. The text messages are in evidence, the ones that she sent to her friends between the time she killed her mom and when she attempted to kill her stepdad. One of them's not, but Thad testified from the witness stand that after he showed up at her parents' house, he and Carly were having a discussion, and Carly said, oh yeah, my mom was holding me down in the chair. She wouldn't let me come out there. And then she texts him later and says, I almost murdered my parents. She was so mad in February that she tells Thad, I almost murdered my parents. And then when I asked Heath about it, when he took the stand, he said, no, Carly wasn't mad. Carly never was angry. He says, Carly never yelled. Ladies and gentlemen, she told us in February what she was going to do. I want you to look at her journals. There's a page back there that says, what do I believe? There's no God. Heaven and hell are false. You writing your own destiny. And these two stand out to me, ladies and gentlemen. She told us what her intent was. You don't need family, and it's okay to be evil.
2 minutes.
That was a 2-minute warning.
There's another one I want you to look at. Dr. Pickett talked about it. She wrote, water, fire, earth. Water, fire, earth. She circles fire, ladies and gentlemen. And she wrote, these are Carly Gregg's own words. Miss Todd stated when we got started the other day, what's better, watching a video of what happened or hearing somebody talk about it? Well, I submit to you, we have all of the above in this case. We got to, unfortunately, watch a video of what happened. We've seen photos of what happened. We have audio of what happened. We have the defendant's journals and text messages telling us what happened. She says, I choose fire. It is powerful, beautiful, and deadly. These are the traits I desire, so I choose fire. Ladies and gentlemen, that lady right there chose fire. She chose to murder her mother, tried to kill her stepdad, and then tried to cover it up. We ask that when you go back to the jury room, that you'll look at all the evidence, that you'll consider the testimony that you've heard, that you will not be misled or confused by the fact that the defendant tries to put a burden on the state that does not exist. We do not have to prove the why. We will likely never know the why, but we know that Carly Gregg is guilty of murder, attempted murder, and tampering with physical evidence, and we ask you to find the same. Thank you.
All right.
I'll tell you, that
I need
closing was
Mr.
fire.
Don Bass and Mr. Philip Hunt to stand, please. Apologize, gentlemen. I've watched y'all. Y'all are paid a lot of attention, but y'all are the alternates. At this time, I'm going to ask Madam Bailiff to escort them to the other courtroom if it's open, or the other jury room if it's open. Please gather your things out of the jury room, though.
Those two jurors.
Once the bailiffs let me know
alternates?
that the alternates have been separated, I'll release you to begin your deliberations. Please do not begin your deliberations until you receive the instructions of the court and all the evidence. Many times jurors find it helpful to pick a foreperson from among their group. Foreperson has no more power than any other person. Highest qualification is you should be able to write legibly so we can read any verdict, okay? Second thing a foreperson can do is call for a vote. Many times disagreements can be resolved by simply calling for a vote and finding out where everybody stands. All right. That being said, let me know once they're separated.
Got to keep them separated.
Did everybody fill out a lunch menu too? Okay.
He's got to talk about
they're separated. All right, ladies and gentlemen of the jury, you can retire to begin your deliberations.
I'm going to start the timer now, and we're going to switch our audio and video. We're switching from the MK counter over to, let's do this. Let's put our deliberation timer up. There's deliberation timer. Now we'll switch to the other side, which is camera 2. Camera 2 becomes camera 8.
All right, the record will reflect we're outside the presence of the jury. I'm going to ask both sides to make sure Mr. Shipley here has a cell phone number where you can be reached, both sets of attorneys. Within 10 minutes of the jury reaching a verdict, I expect y'all back in the courtroom ready to go either way, okay?
10-minute window.
I want y'all to get together, make sure all the exhibits are present and accounted for, and that any exhibits marked for identification are separated. All right. We'll remain in recess till such time as the jury reaches the verdict.
So 1 minute in on deliberation, Carly talks to, I think she's got both grandparents there. I think that's both sides. Her stepdad is not present. We don't know that her dad is present at all. She's talking to the bailiff a little bit about what happens next. Judge follows her out with his red Solo cup. Did you see that? I think it was a red Solo cup. It might be a coffee cup, but it looks like a red Solo. We're hearing that Biodad has been in a few times. There was a point during this that was, I can't believe defense went there when they said the easy story that Carly could have shown told when the cops showed up was, and she laid it out and basically saying point the finger of blame at her stepdad and alleged that something inappropriate had been going on there. That there's zero evidence. As a matter of fact, all the evidence we've heard in court was that nothing had gone on. There was nothing there. And for her to bring that up, that is that was crazy. We don't know why her stepdad's not there. He could have a conflict. It could have work that literally just won't let him go. I don't know what he does for work. Maybe he just didn't want to be there when defense laid it out on the line like they did, because that was brutal. That was fire. That was fire for sure. Red Solo Cup, you mean Canton evidence collection container? You say potato, I say potato, Carrie. Same difference. He's a physiotherapist, a physio. Check the timer. Carol, what timer? We're looking at the timer. What do you need me to check, Carol? I'm not sure what you mean by that. We are going to watch, we're going to pick up where we left off with the Sarah Boone hearing, which happened, yesterday? We're going to pick up and watch that during the break while we wait for them to deliberate. While we do that, though, I have to do one more poll. I apologize, I'm a little late on this one. But we already had the poll that, as far as what the jury verdict will return, and the results on that were guilty as charged, 78%. Hung jury, 14%, or not guilty by reason of insanity, and the two options included in there, only 7%. That was with 1,300 people voting. Next poll, as always, is going to be the deliberation timer. How long? How long will deliberations? If maybe we'll work delib. Take. And we're going to have, let's see, let me put a couple options in here. I'm going to say 1 to 2 hours. 2 to 4 would basically take us to the end of the day, pretty much. There's a bug on my microphone. You see that? Okay, just 1 second. All right. There we go. Verdict is the deliberation timer is now up. Our options are 1 to 2 hours, 2 to 4 hours, Monday morning verdict, and can we stay for pork chops is option number 4, meaning that midweek the jail does serve pork chops to the jury. So we'll see what that could influence things. It really could. No, we're not going over to Diddy. That, can you imagine that? That is a tough case. We are going to go over to Sarah Boone, though. We're picking up where we left up on the Sarah Boone hearing, as she's slated for her jury trial to start on the 7th of next month. So that's going to be, let's see, there it is, camera 7. Make sure we have some audio with this one.
The 2-minute video and the short second video, and they had found it on her phone.
Oh no, just jumped majorly. Don't know where we left off. Let's see if it's right here.
I don't know why. She's sitting there reading it, and
does the fact that that question was not read impact
Give me a second, we'll get that
constitutionally under case law the admissibility of those statements?
I believe so. Along
That doesn't
with
answer
her
my
other two
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper. That they're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the Sheriff's Office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay. Thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is, I think state versus right is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing, and we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll have to ask Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
get you my copy?
And Mr. J, have you seen that, sir?
State doesn't have a dog in the fight with the expert appointments.
Understood. Thank you.
Judge, what I had done was
Don't see a date on here, Counselor. When was this sent? The certificate of services contains no date.
It's not a very good certificate of service.
It was filed this afternoon,
Okay.
this morning.
Okay. What is the
we have an Olympic
the
timer
other
going. Hundredths of a
motion
second.
related to costs, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last...
When was that, you're asking nunc-pro-tunc to win on that? Also to the August 30th date of your notice of appearance?
If possible, yes. That's when I officially got on the case.
Okay. Now, as to the third motion for costs, I don't have a copy of that, unfortunately.
Can I approach?
Yes,
Donna,
please.
happy birthday. Make sure we sing to you on Monday.
Judge,
We
I
missed it
mentioned
morning.
this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I had mentioned him. He had served
being
as an
tried as an
expert
adult,
in
so she would
the Marsha
stay.
Thompson Palm Beach County case.
I recall.
Or possibly
And so,
juvenile until she's
as you
21 and
know,
then transfer.
he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Berkland, and it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion, under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These
Order
two
them to
other
produce
people,
reports.
I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. That's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Is it Central?
Is that in person or is that virtual?
I believe it's
Okay.
The state's flying in, and I'm going to be their judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion,
so backdates them.
The motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick.
Sure.
Give me a minute.
Yeah, you're good.
While they're doing that, I did close out the poll on the jury deliberation. We had about 1,000 votes on that. How long would the jury deliberate? 2 to 4 hours was 61%, 2 to 4. 1 to 2 hours, only 13%. Monday morning verdict was 15%. And can we say for pork chops, it was 9%.
It had to be filed.
I love that Judge Kranick just issues orders from the bench. He rules from the bench. So many judges rule
While
from
you're
their
waiting on
chambers.
that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones. It had to be filed prior to
It's sitting on somebody's desk somewhere.
prior to my motions for appointment of these experts.
Give me a second.
I don't think Boone's going to fire her lawyers during trial. First of all, they don't have long enough time for her to really get mad enough to fire them. Usually takes at least a month to do that. They've got less than that. Plus, I think she knows now this is her only hope.
Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided.
Sarah Boone has 2 other attorneys that are on
Moving
Zoom.
now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense.
That's her cell phone.
Mr. Owens, you may proceed, sir.
She wants her cell phone back. They've had enough time to look at it. We want it back
Judge,
so
I
that
believe
she
the
can use
state's
it.
response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone.
Carly is in verdict watch. This is Sarah Boone's hearing from yesterday. We're catching up on.
We would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
That shirt was
Mr.
designed
Cacciatore, good
made
afternoon,
by
sir. Can you
Greeners
hear
in
us?
chat.
And if you can you announce your presence for the record, please?
We're going to turn this down. It gets loud. I put some limiters in, but it's going to get nuts.
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir.
Greeners, do you have the link for where you can get that shirt?
There was a John Sawicki that was appointed back in, or not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best. We've got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Enlargement of time? Can you slow down the
on the
passage
15th,
of
an
time?
amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
You'll hear argument, but I think he's ready to rule right
Start my
now.
argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
That'll kill our ears.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't.
One horse, one rider.
Administrative rule says argument, so I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. Okay. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it.
Plug your ears.
All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance, and Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phones. So we're diligently trying, number one, to review all the discovery, which still has not been done, at the same time trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If, in fact, he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical records, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense, it is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome, and here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her.
She'd have to
So
testify.
she'll need to testify.
Boom.
And then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case, allows the state to point out the things that are promised in a defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Okay, this
Judge,
might be noisy. Let's. Well,
they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice, and I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't.
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
it's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the
audio's cutting in and out here.
Located. Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase? Was that the overt act that caused the death?
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at bar?
I assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
You guys are eating popcorn. I'm unboxing our newest switcher. It's identical to the one we use right now, but this one has SDI, professional SDI outputs on the back. Outputs and inputs. Gives me 2 more outputs and eliminates about an 8 millisecond delay in the processing of video.
The defendant stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm.
211 buttons.
What's the
mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase, against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
She's going to have to testify.
That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
This changes everything.
Not accident, as they want.
And it guarantees, Sarah Boone takes
Does your
the stand.
compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us?
It's going to be loud. I've got a limiter on.
If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
But I have some concerns because I'm getting reverb from you.
You've got a crappy speakerphone.
I am trying to talk you too down. Are you able to hear me better?
I am, but it's my that
it's
we're
so
hearing
bad.
back again through your microphone.
So turn your volume down, sir, until you're done talking.
Turn that volume down.
All right, this may work.
It's bad. I've got limiters on so it's not blowing your eardrums out. This may work. By may work, we mean it's probably not
Mr. Henderson,
working.
we'll give this a shot, sir. You can go ahead.
Yes, sir. Can you hear me now?
I can, sir.
Is that better?
Yes,
No,
sir, it is.
It's terrible still.
Yes, Judge. I'd like to respond. But first, where I want to start is here. But just the self-defense, justifiable use of
Where's he looking?
deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just some scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome
I'm trying to
is
fix
not
this.
a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger,
Imminent danger.
and that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the self-defense instruction requires is that the jury place themselves in the position of the defendant. In those circumstances, at that point, battered spouses to help explain those circumstances. So the first instruction that you have to get before you can even start talking about battered spouse is this. You have to get the self-defense instruction. So, and that will be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense, this is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where battered spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify?
This guy's back to the judge.
Gaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was the interviews, this was reviewing other type of data and other
I'm going to fast forward this. It is that bad.
their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide
3 more minutes of this.
That battered spouse is a defense. What it will talk about in the jury instruction is this is something in the bathroom will do.
Okay, we fast forward.
So then you're just on self-defense at that time. But that argument and that decision can only be made after
He's wrapping up.
the evidence is put in that trial.
Okay, there we go. Whoa.
That's all I have, Judge. Thanks.
That was terrible. That's what it
Mr.
was.
J, any response?
Can you mute him again, Judge?
It sounds like we're largely on the same page.
Thank you.
The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's in Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery.
Spent time in jail for that.
But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then like everybody else, we were playing hide and seek, and he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Not Mr. Henderson.
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir?
Please no.
You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
Please stay that way. Hope he never figures this out.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper. Who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue, and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process. And
He's almost done.
We add more.
There we go.
But that's all I have.
Thank you.
All right, thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th.
And biggen the clock, please.
Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but
Really?
Yeah.
Does the judge have them?
I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates, and I think that's a typo on paragraph 3. I said August 17, that should be September 17. On paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door
Hey, Brandon.
to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him.
Brandon, you out there?
As you know, 4.5 years, people move, so
We'll see if we can find him for you,
is my point.
Mr. Owens.
We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay.
Mr.
I'm just
Owens,
rereading the rule.
I might
Give
have
me a
found
moment.
your guy. Still lives in Orlando, Florida. It was that hard. It was on Facebook. And if this is him, it's going to be some witness. Oh, my goodness.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
so my intention is to run 50 people in the morning. So that, I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning. Get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right.
Additional
I'll see what
witnesses.
I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for a continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Please have a good mic. Please, Mr. Lake.
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. We were not contesting it beyond objecting. We do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour.
They are going to pay.
That does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert that's being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name. I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real other than objecting to the rate because it does exceed rate for the circuit. We don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense, but that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
No, it's in excess of the rate for the circuit. Those were the rates that were adopted back by the old Immigrant Services Committee back in 2007. We essentially generally don't
I'm going to skip ahead.
ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, that the rates generally range for mental health experts range between object to them based on our
we're skipping ahead.
Circuit.
Okay, all right.
Sorry,
the court
that's
is going
too
to
bad.
grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc-pro-tunc because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September?
Yeah, is that not what I just said? I'm sorry if I said a different date.
You said February.
I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
And we're hand delivering some motions for the judge to consider right now. It has to be another hearing.
This relates to the investigator, Billy Lane, who's working with the defense.
Billy Lane.
And his potential costs.
From Prison Break Investigations.
Up to the trial.
Oh, he needs
Are these
more
being
money.
hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes.
That's fine.
So do I need to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you can get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to
do her
fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay.
You're going to have to.
I believe that's all I have, Judge.
Can we bring
all right.
great clips?
Anything else, State, we need to address?
To the jail.
All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
And with that, we are done with Sarah Boone. We're caught up. That takes us just back to, back to reality, right? Let me jump back here and turn off camera one. There we go. That one's gone. So we're now an hour and 22 minutes into deliberation in the Gregg trial. We're expecting to have a whopping 10 minutes of notice between when the jury turns the verdict back in and when it goes live in the courtroom. How fast that gets out through media channels, I don't know. So we'll keep our ear to the ground here as we're moving forward. Sarah Boone motions. This is interesting. It is interesting to see that a month ago, Sarah Boone was sitting by herself arguing for no belly chains and handcuffs so she could take notes and provide her own self-defense, pro se. But then she went out and did this. She wrote a letter, right? And the letter, this is one page of the letter, had this ad. It says, "Inmate seeks attorney. Looking for a prosperous challenge." I've got to move the mic here so I can see. Looking for a prosperous challenge? Ready for your close-up on television, like actual TV? Are you zealous with a side of keen? Show the world who you are with your, original creativity, experience, or extraordinary experience, and confident ingenuity. She's got a list of everything. This ad worked. She sent this ad and said, "Judge, hang this up in your break room so any lawyers who come by will see it." Greeners put it on a shirt here for me and sent it to me so I could wear it. I did wear it. I'd like to think that maybe Mr. Owens saw me wearing it, and that's where the attorney came through. The shirt, Greeners made this. I did not make this one. Greeners in chat made this one. I can post a link if you would like it. Let's see. That's not it. Oh, there it is. So Sharon just posted the shirt. You can buy that shirt. That's set up from Greeners. I think it's a pretty good price too. It's not exorbitant. Anyway, the shirt link is right there. You have to scroll up just a tiny bit in chat if you want to see that. But it worked. It worked. She got not just one lawyer. She got 3 lawyers, and one of them brought 2 assistants. So she now has a team of 5, possibly more if the other 2 lawyers have assistants as well, which is a full crew. I mean, that is more than Brian Koberger has facing the death penalty in Idaho. She's got 5 people working for her, all from this ad. So if nothing else, she has a career in marketing from inside. Greeners has taken a loss on this, apparently. Street clothes for walking. Love the jail orange color. Great job with the shirt. Greeners is amazing. Not only does he come up with some creative stuff like that, he also helps out a ton with documents and just keep letting us know when things happen in trials that we're watching. Let's go back to court with... Oh, I'm moving around all over the place. Let's see, where are we at? Let's run to A. Let's go back down there. All right, we're deliberating. We're almost an hour and a half into this. Back in the Sarah Boone thing, they mentioned the name, and I'm not going to say the name, but they mentioned the name of somebody who might be the next door neighbor that shared a wall with Sarah Boone, and they're looking for him. I just did a quick search on Facebook and found somebody by that exact name who lives in the same county. And if it's the right guy, first of all, his profile picture, I think he has a bong in one hand and a 40 in the other. Testimony is going to be amazing. Testimony's going to be amazing if that's him. So that'll be interesting for sure. Didn't know you could request a stylist. We have seen people that have some makeup and everything, so that is possible. I don't know. We'll see if that's him. I don't want to out the name, or obviously not trying to dox anyone, so we don't want to do that. But they mentioned it in court. I just did a quick search, and it seems like he has the right name, which is not the most common name, and lives in the area. And if he's the neighbor, wow. All right, what can they do to her hair? They can, well, whatever style she likes, pretty much. I'm not sure if they're going to, like, she gets a full perm and a dye, but they might be able to curl it or comb it or something similar to that. I don't know if they ship the shirt to South Africa. I'm not connected at all, other than that Greener sent me one of those shirts. I make nothing from that. They'll probably give her hair ties and bobby pins. Maybe, I'm thinking ponytails, or possibly a smaller version of the Princess Leia look might be an option for her. Might help a little bit. Off topic, but Judge Fleischer is wearing a Pac-Man suit and tie today. Vicky Mack is a YouTube channel that does a lot of following with Judge Fleischer. Actually connected with him, talked to him. I think he's been interviewed on her channel as well. That's a great place to go to watch him. Vicky found Judge Fleischer, and Vicky's doing great stuff on her channel. I feel bad using Judge Fleischer when I knew nothing about him until Vicky came along. So we probably won't watch much Judge Fleischer, maybe some highlights now and then. They might give her a wig. They could. I doubt it. Fleischer does allow restreams. He's said no, and I have to wait and see, because I think his stream says no. But he's, Vicky's in South Africa. Judge Fleischer actually has a connection with South Africa, I believe. We'll see. If he's cool with it, we might start adding it. But for now, I'd recommend checking out Vicky Mack's channel. Let's see. You said yes when talking to Vicky. Oh, Josh has found another gem hidden in the archives from yesterday with Judge Simpson up there in he's in Michigan, right? I think he's in Michigan or Wisconsin. I can't remember. I can't remember where Simpson's at. I'll send that to the burner phone. My phone, my computer, my system that I normally watch Judge Simpson on is tied up with our current feed. And I'm recording that, so I don't want to change that around. Can we watch some YSL to pass some time? We could watch YSL to pass some time in Koberger's case if we wanted to. It'll still be going then. Washtenaw, Michigan. That's right, Judge Simpson. So your thoughts on the two cases so far today? If you watch his interview with Vicky, he covers that anyone's free to rebut. That's good to know. Thank you, Tom. Appreciate that. YSL still going during Koberger's, your bet? I think so. Koberger's what? Is it March? Where'd they end up? Are they March or June? I forget where they ended up with Koberger. I like Judge Fleischer, but at the same time, some of what he does is just for show. Like it's performance, either for the live stream or to make more of an impact. Like he's bluffing. I don't know what else to say. He bluffs. It's bolstering. He's trying to scare people straight. How long will I say until the verdict? I think it's going to be today. I'd put it in the 2 to 4 hour range, which puts it with the majority, I believe, here. Thoughts, says Anna Banana? Both are guilty. He wants to be memorable. He does. Or he wants to be memeable. That's probably why he's wearing the Pac-Man suit. I'm still not understanding how Sarah zipping George up in a suitcase is in self-defense. I can see how they might spin this, Ashley, with her saying, I was afraid for my life, and even though it was good right then, I knew that it was about to snap, and I just couldn't handle anymore, and I took the only opportunity I could. But how that is going to play with the video that she took during him being locked in the suitcase, I don't know how the only way they can get this as a self-defense claim in front of the jury and have even a slightest smidgen of hope, like a scintilla of a chance to go forward, is if they're able to throw out the interrogation and the video, which there's no way they're throwing out the video. I guess if they throw out the interrogation and say she was coerced, and that's she had already turned over her phone, they'd have to also say that she, it was improper the way the police got the phone. Both would have to be gone. The video has been released. I don't think the full thing has been played in public, but enough of it has been played, it will make you sick. You can hear George begging Sarah to get out of the suitcase, saying, "I can't breathe. Sarah, please." It's going to be played in court, and it's heartbreaking. Koberger is scheduled for June, but that could change. We'll find out the hearing next week, which I'm going to try to attend. Great. Denise, thank you. That is going to be, Koberger got moved from Latah County to Boise, which is in Ada County. And that's a huge win for anyone who wants to attend the trial. First of all, Boise, the courthouse, is beautiful. It's right there on the riverfront. It's downtown. There's a lot of hotels nearby. There's a lot of food options. There's Latah County, not so much. It's not the place where there's a lot of room, but Boise's going to be great. There's an airport nearby. We can fly in. I think it's going to be much better. I think we're going to have, hopefully, fingers crossed, better options for video coverage, even if the judge does still maintain control. Weatherwatch says, "I apologize to all the Cowboys fans regarding the podcast last night." Nah, just kidding. He's still rubbing it in. Would that be the Daybell Courthouse? Please don't be the same. Was Daybell in Boise? Please don't be the same judge. I just cannot. Yeah. Will I be attending in person for the whole trial? This depends entirely on what the setup is for audio and video. If I have to be there to get the live feed, then I'm going to move to Boise for 3 months, which sucks. I mean, it's good. I was just up there, but we'll figure out. If I have to be there to have the feed, we'll do that. If not, if the judge provides the feed, I still might want to attend for portions of it. We'll see. We'll see what happens. I do have another commitment in that same area next year as well, in that same time period. So if the two coincide, I'd like to attend. It's going to be a different judge. Do we have the judge's name? What's wrong with Judge Boyce? You saw the camera angles he provided for Daybell, right? They were terrible. Terrible. I need something better. I mean, Judge was a little bit better. At least we got multiple angles and everything, but it's Judge Hippler. That will be a long visit. It will. I'd almost become a resident if I stay for 3 months. I think 6 months is where you become a resident. I'd have to file taxes in Idaho. That would be terrible. I'd become an Idahoan, and my mascot would be a potato. I can say that because my wife's from Idaho. Let's see. Anybody know what Lori's Arizona trial? Didn't Lori just barely get a possible delay in her trial? I was seeing something there. And we've talked about this a little bit. Hang on. Couple things. First of all, remind me to talk about Kentucky. What is the Trial TV site? Trial TV Live. They're friends of the channel. They're also a YouTube channel. They're just starting out, getting going. They're all about transparency and providing court feeds for everybody. We're working together on Sarabun specifically, trying to get that in place. Now, Kentucky. There's a story just out of the headlines just the other day. Crazy, crazy story. Might end up in a court case. If so, we'd like to follow it. There was a judge that was in his chambers with the sheriff. Not just a sheriff's deputy, but the sheriff of the county. The sheriff shot and killed the judge in his chambers. At the courthouse. and the sheriff's now been arrested. So that might be a very interesting trial to follow. The judge died. The sheriff's in jail. Usually the sheriff controls corrections, and so the sheriff's deputies, who I guess he's still the sheriff, okay, because he's going to be the sheriff until he resigns or is ousted. It's usually an elected position. He's the sheriff over the corrections officers who are keeping him locked up in jail. Wild. All right, you found it. Thank you. Awesome, Robin. They're worth a follow for sure. Good people over there. The motive, though, that's going to be the story. There are some rumors out there that are quite salacious, but the motive is going to be like, I'm not sure if we can cover it. Depends on what the motive is. Good old Judge McBurney has a trial going on right now. Only thing I don't like about Judge McBurney, he tells everyone to get closer to the microphone. And it's terrible. It's like, no, there's a sweet spot. Find the sweet spot and stay there. Ari's channel is getting spicy. We've got a couple good ones. Lately. Arraignment Monday in a different county. Okay, that's probably good. Different county would be appropriate here, and maybe he'll get a change of venue. Everybody knows the sheriff. Melissa, thank you very much for the kind words. 1 hour, 38 minutes into deliberations for the Carly Gregg jury. We had a couple options of 1 to 2 hours, 2 to 4 hours, which I chose. Monday verdict, which I think after 4 hours, I think we're pretty much going to be done for the day. There won't be a lot left, considering there's going to be a break for lunch. They most likely won't deliberate through. Let's see. Thank you for I'm getting more links to some of the videos we're going to watch, possibly at a later point, maybe after lunch today. Kanalunu, how do I say this? Kanalinonu? That's the best I can do on that one. Welcome to the gallery. Thank you very much. Would my whole family join me for the 3 months? They might. Let's see. We just did a month and a half. Here's the thing. I'm not sure if I'm ready to drive across the country again. Looks like we have a court watcher who might be down in the Carly Gregg trial for the verdict, headed down there right now. We'll wait and see if they arrive before we announce anything there. Let's see. Yep, going for the verdict. Good. Her name's Sarah, by the way. So she might be there for the verdict for the Carly Gregg trial. If it happens here this afternoon, bring the family to Boise. Boise's a good city. It's a good place to go. They're tearing down Chad Daybell's house. They're almost done, I think. Following the updates on Twitter, I think Nate, who was a critical part of the entire case for the Daybell trial, has been following that as well. I missed the name. What was the name? Show me. Oh, Can I Lean on You? Can I Lean on You? There, I got it. Okay. Thank you. Can I lean on you? I was trying to pronounce it as if it was all one word. Can I lean on you? Okay. Let's see. We've also got the Donna Adelson trial, which is delayed because of the objection, non-waiving conflicts, with Charlie's lawyer being the same lawyer as Donna, and he refused to waive that. Let's see, we might see if we can Where could I bring Judge Simpson in from? Let's see on Channel 7. Let's see if we can jump into Judge Simpson's court really quickly. He is live right now. He's just starting up. That would mean we turn on camera 1. We'll make camera 2. Actually, camera 2 is down here. Make camera 3 be Judge Simpson. There we go.
Or through mibridges.wish.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 734-961-1999. Additional assistance is also available to the Washington County Veteran Services. Their phone number is area code 724-973-4540. Also, you may obtain housing assistance and other resources. Coordinated entry resources.
His audio is especially bad today.
Their phone number is 734-546748. You do not need a judgment to obtain assistance from any of these agents. The summons and complaint are sufficient.
We have seen Darren in court once before. I forget what he was for. These are all the notices that apply to everybody.
You have a right to reach an agreement.
I'm going to turn this off while he's reading these. I think it's a recording that he's playing actually right here. That's why it sounds so terrible. Anyway, this is all the notices of everyone, their right to court, what they can do, who they need to contact. You say there might be a verdict. Virginia, we're in verdict watch right now. We've got the timer going. They're at 1 hour and 45 minutes into deliberation. In the top left-hand corner of the screen, that's a live view out of the courtroom in Mississippi for the Gregg trial. The main picture we're showing right now is Judge Cedric Simpson, who is about to start a little bit of a docket work today. So we're just going to stay following that for just a moment while we wait for an update. Okay, we're going to remove slow mode here from chat. Just 1 second. There we go. Slow mode is gone. You can chat as to your heart's content right now. How about that? I'm free, says sorting chat. Now you were free already. Anybody in green doesn't need to worry about slow mode. Beryl Forster says, Recovery Addict, can you congratulate my grandson on passing his first year of university? He is studying forensics and criminology. Beryl, your grandson sounds like somebody who's after our own hearts, loving crime or the different careers associated with prosecuting it. Forensics and criminology, that's got to be tough. See some crazy stuff there. Congratulations to Beryl Forster's grandson on passing. Congrats. That is really cool. Can't wait to see you in court testifying. That'd be awesome. All right, so let's jump back and see if we've got the judge talking yet. Let's see, I don't think he is. That was a recording. He should be back on shortly. Did defense throw Carly's stepdad under the bus? Sort of, Judy. They said the easy thing for Carly to do would have been to blame the situation, which did not occur, on her dad and go through details about that. And it's like, okay, and they said that would be a lie. So in a way, they're saying that's not true, but they presented it to the jury, like, to think about, which was, weird. Points are not working. You can check your points, but they do not change. I'd rather you don't check your points. It just takes up a ton of space in chat until we can figure out how to get all the comments to not show up in chat. We're going to leave points off. Let's see. My profile picture is just for this group. My sorry counter mug. Love that mug.
You may be seated.
We are starting.
Okay.
You are green.
Court does call the case of Beale Properties versus Mary Burks.
Oh, it's landlord stuff. It's tenant landlord. Oh, it's Friday, of course. This is where we deal with
Good afternoon, Your Honor. John Capitan, P61901, appearing on behalf of Beale Properties.
Your name? Oh, she's
my property manager, yes.
Mary Burks? She's not present. How would you like to proceed, counsel?
Your Honor, we move for a default judgment of possession.
And if you raise your hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, full truth, nothing but the truth?
I do.
All right, go ahead.
The rent to retain is $1,698.40. The costs are $175 for a total of $1,873.40. We ask that a writ may issue after September 30th, no money judgment.
All right.
I do have a
Yes, you might want to place under paragraph 10 to release escrow to plaintiff. That's in the amount of $125. Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ issue in 10 days, and I will sign that judgment upon its presentation.
That's what happens if you don't show up to court. The other side wins by default. So we get a lot of those.
Call the case of Ivana versus Terry Jack.
Thank you, Your Honor.
Thank you, sir.
His name is Darren, and we've seen him in a previous hearing, but I don't know what for. We'll hear when his case gets called.
James Nelson, on behalf of the plaintiff.
Good afternoon. All right, where are we now?
Well, Your Honor, I think the last time we were here, instructed Mr. Jackson to bring an additional sum of money to the court by today's date.
Did you get that in, sir?
Yes.
There you go.
And Hawk what's Hawk's status on this?
Hawk has agreed to pay the amount for us remaining. It's split between two payments between SOS Services and BNB paid. So the remaining $3,000 will be paid. Yeah, it was mailed out Wednesday.
Okay. Amy, can you help me?
Your Honor, I need a minute to.
Oh, okay.
I have the email thread.
Well, anything else you want to say that I'm not listening to? Because I'm trying to get verification. And Mr. Nelson, so that you know, I do have a total of $3,400 in escrow. So.
Correct, Your Honor.
And what was the current balance? Well, she's
6,129.
29. Okay. Subtract that 34 from that.
2729.
Thank you.
I apologize for the wait.
No, it's not a problem.
I was not given a specific note, so I'm looking for another place to.
I'm sorry, you're.
I was not given a specific note from the caseworker, so I'm looking up from another place to verify what he's making.
Got it.
Your Honor, we did receive similar emails.
You did?
Yes.
Saying that how much was did they tell you how much would be paid?
3,000.
$3,000. And
Have not received the money.
have not gotten it yet. Okay. Did they say, like Mr. Jackson was saying, when they mailed it out?
They did say that. They said that we should be expect payment within 2 weeks, although they said it was mailed on Wednesday.
On this past Wednesday?
Correct.
That's the 18th?
Correct.
Well, I can do, how much is your monthly rent?
1150.
All right. So I can do one of two things. I can put it to next week and see if it's paid. If everything's paid, I'd release escrow. So then if everything's paid, the case would be dismissed. Or what I can do is I can adjourn it to the first week in October with the escrow and then the payment from Hawk. We'd have about I think if my math is right, $271 toward October rent, and then try to figure out when he's going to get October rent paid. I'll do it either way for you folks. What?
Like to do it in some manner where we don't have to come back here.
You know, I've known Mr. Nelson forever, and I always liked it, but he just doesn't want to come back and see me. I'm not. I'm hurt, but I'm not. I'm okay. When were you expecting to get October paid?
On the 1st, Your Honor.
You're going to pay October on the 1st? Pardon? Okay, I believe that will happen, but realistically, when you're looking at, when do you think you're going to get it paid? I mean, the 1st is a Tuesday, but realistically, when do you think that's going to happen for you?
I get paid on the 1st, Your Honor.
You can get it paid on the 1st? All right, then here's what I'm going to suggest we do. If you get that paid on the 1st, the check hopefully will be there. I'll release escrow. Just check on the escrow, because if that's the difference, then we've got it. So you can bank on that money. I would adjourn it to the 4th with the hopes that Hawk is paid, you've gotten the escrow, and he's paid October, then you can just send in a dismissal. That way you don't have to come back and see me, Mr. Nelson.
Do we need an order to release the escrow?
I'm going to write it on the file and they'll send it to you.
I'm going to interrupt just for a second.
I'll take care of that.
Okay, just for a second. We're getting more information on that Kentucky sheriff, and I want to nip a rumor in the bud. Not in the butt, in the bud. There was a rumor about the judge being involved in some nefarious relationship. We're getting more information that there was a deputy under the sheriff that was involved in a abusive relationship with a potential inmate or a defendant, and that there was a disagreement between the judge and the sheriff about the sheriff's training that allowed that to take place. So that's where it starts. Apparently, the sheriff was facing a lawsuit about not adequately training his deputies. So that's the story. We'll keep an eye on that as it moves forward. The sheriff is in custody, and the judge is dead. So, wow. I imagine there's probably some courtroom footage. Probably not in the judge's chambers. That's not a place they usually run cameras. But there's probably, footage of immediately before or after that might be in the hallways that might be played if this goes to trial. If not, I don't know. We'll probably never know. All right, let's jump back to court. We are just approaching.
Plaintiff Jorge Ortega.
All right.
We're on muting the judge. We're approaching the 2-hour mark on the deliberations. In the Carly Gregg case. We'll keep an eye on that. That's live up in the corner. We've got audio turned on. If something happens, you'll hear it. But we're jumping back to Judge Cedric Simpson, who is live right now at a Washtenaw, dealing with some landlord issues.
Trial available date for your jury call in October or November?
You answered the counter complaint.
In the process of doing that, Your Honor, I was planning on having it before today because I think I've got in the interim, my son had a baby, so it's been a little
Congratulations.
Congratulations.
Thank you.
I think we ought to celebrate and just get rid of this case. All right.
See, the last lawyer didn't want to come back.
Yeah, I know. I didn't say I didn't want you to come back. I like things being resolved. Let's do this then. If you're going to answer that, prior to me setting it so that you understand my process,
okay,
I would set it for a final settlement conference where you guys would come in and we'd try to see if we can hash this out.
Okay.
If we can't hash it out, then it will be set for a final settlement conference and jury selection, which will be a Friday and a Monday. So right now, what I'm going to give you is a Tuesday date to come back.
Okay, just everybody. Okay.
Will that work?
Yeah, that's fine. That's fine, Your Honor. I would just ask, because they demanded the jury, I'll reiterate my motion for escrow.
Yes, I will order escrow.
Thank you, Your Honor. I'd like to argue against.
Go ahead.
First of all, the statute, the court rule is clear that you should consider all relevant factors in this. This is a very unique case. Mr. Ortega and Ms. Gonzalez were boyfriend and girlfriend living in.
We're going to do this right here because we have motion. All right. After nearly 2 hours of deliberation, sorry, trying to get everything sorted out here. The rumor, we have a verdict. We have a verdict in the Carly Gregg trial. The jury who sat through what was 5 days of testimony has in under 2 hours reached a conclusion where they all agree on something. I'm sorry, that was loud. That music was loud. I had my volume turned down. It was louder than it was for me. Carly Gregg faces 3 charges. The first of murder. The second, attempted murder. The third, of tampering with evidence. The jury in under 2 hours was able to reach a conclusion on all 3 of these. This is not a question. This is an actual verdict. I've got to say, this does not look good for Carly. All right. I'm sorry. For those that are new here, yes, we do have verdict music we play every single time. Usually it's not so loud. I apologize. I'll turn it down. Music was way too loud. We have a verdict in the Carly Gregg case. We're waiting in moments. We expect, they said within 10 minutes. With 10 minutes, the loud music is to get everyone's attention because people step away and verdict watch. But within 10 minutes, we should have the jury back in the courtroom reporting their verdict to the judge and to Carly. Everyone has been told to be here in place within 10 minutes. Family, everybody should be waiting. It looks like prosecution is there. Don't see any, well, there's defense. Prosecution, Miss Todd from the defense. Is it Miss Todd, right? I think that's her. 1 hour. I stopped it at 1 hour, 58 minutes. It probably came in just a couple minutes before then. So it's definitely under the 2 hour deliberation mark. We have a verdict. We'll leave that up here on the screen just for a little bit. Before lunch, a pre-lunch verdict. Apparently the pork chops were not enough to keep the jury in deliberation until next week. But thank you, Amber, for that. Kiki D's Garden gifted a membership. Thank you, Kiki D. I appreciate that. Amazing. Kayla Newell, what? Verdict and 1 year and birthday month all in the same time. Congratulations on the 12 months. You got that orange courthouse by your name as well. Well earned. Let's see. We're trying to get all the feeds lined up so we can have the best audio as well as some safety fallbacks as well. Okay, there we go. Let's mute that one. It's going slowly. This was a fast verdict. All right, you can see that most of the families there were still missing, I think, the grandparents. There's the dad, the gentleman walking in right now in the gray suit, and Carly at the same time. That's the stepdad coming in, sitting down. Carly's coming in right now, which means even without the grandparents here, they might start right now. Come on, camera 3. 1, 2, 3. Where's my audio? Showing no audio from the court right this very second. Only 15% of us were right. I guess 1 to 2 hours, you're correct. Bubba wasn't up to grilling today. They declined the meatloaf and said, we're going to get our own lunch. We'll be done in time to go. This is sad. This is what I believe is as a young girl who threw her life away and in the process took someone else's. And not to mention all the family and friends who have been devastated by this. And it's just, there's Mr. Smiley himself. There's Heath Smiley. That's the father-in-law. I don't see a look of optimism on his face. Carly is extremely anxious. You can see the breathing rate is high. I think she's close to tears right now, just waiting for something to happen, waiting for the judge. Still no audio from the courtroom. We saw a motion from Carly at the beginning of the trial and saw a motion from Carly at the end of the trial, and not a lot of emotion in between. Okay, let's see if people are coming in here. There's the tissue. I said father-in-law. I meant stepdad. I'm sorry.
Just let you guys know also.
Yes, let us know what. We're just waiting for audio. I'm monitoring all my different channels at the same time, so apologize. Jury reached a verdict in under 2 hours. I'm thinking that Dr. Pickett was quite key in this. What if the judge will go on the defense after this? Go in on the defense. I think there might be some comments afterwards, but I think most of the comments he makes today are probably going to be directed at Carly, unless there's a pre-sentence investigation. If a PSI is ordered, it extends the time between sentencing, between verdict and sentencing. And I'm not sure exactly how they do it in Mississippi. Sometimes they switch straight into sentencing phase, and other times there can be up to a 3-month delay. Okay, there is, I believe, Mr. Smiley's mother. There are the grandparents coming in. There's one waiting for grandma. There's Grandma. Okay, I think everyone is present. Don't see the gentleman that had the beard. I think that was the other grandparent. Dr. Pickett rocked. He was really phenomenal, especially for being a first time he's testifying in a criminal case. I think her plea option was 40 years out after 20. Parole, good behavior on 20. She turned that down and said she'd rather, chance it with the jury. Just waiting for the judge. She turned it down. She said no. I guess the big question in everyone's mind is the jury going to, it's not a question of whether she's going to be found guilty. It's whether she's going to be found not guilty by reason of insanity. If guilty, she'll stay in isolation until she gets older, and then she'll be in general population after that. There's the judge.
All right, please be seated. All right, the court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. These people did not ask for this job. They didn't want the job. The state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. It is a 30-day jail sentence for every outburst.
Whoa.
I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time.
Except for Carly.
Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury.
So for the last time in this case, this jury is brought back in.
You will bring the jury.
Trying to overlay images because we've got some feeds that are good and some that are bad. So give me just a second here.
You can sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts.
Yes, sir.
All right, if you would, please hand the paper to the bailiff.
In any of these counts. That's something that Judge Cannoni didn't say in Karen Reed's trial. Judge will check the verdict to make sure it's filled out properly. That by law, it has to be.
Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count one. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count two. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count three. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count one, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes. Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry. Yes. On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count 2, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row. Ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes. Ma'am, is that your verdict? Yes. On the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count 3, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row. Ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes, ma'am, is that your verdict? Sir, is that your verdict? Yes. Ma'am, is that your verdict? Yes. On the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right. All 3 verdicts appear to be unanimous. The court will enroll the verdict. All right. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Okay, sentencing phase begins.
The state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce 1 photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct.
Show your piece of evidence to the other side.
The jury gets to decide the sentence.
Any objection?
Yes, Your Honor.
Y'all approach.
There's been an objection to the one picture that the state wants to introduce in the sentencing phase. Sometimes the sentencing phase can go on for days. But in this case, they've said basically just ditto everything that happened before, move all the evidence from the trial over into the sentencing phase, with the exception of this one picture, which the jury would see. And then the jury considers everything they've heard during the trial, in addition to anything they might hear from the defense during this trial. Now, from the defense, you may have witnesses, specifically family members, that might testify. That might say these are the mitigating circumstances. This gives the rules for what comes in during the sentencing phase are a little broader, and so we might be seeing and hearing from family members on the defense portion of this trial. I don't know what the picture is yet, but the defense has objected to it. Stepdad did say it's okay.
All right, the state has moved to adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
No, sir, Your Honor.
All right, defense may call any witnesses.
Do they have anybody?
We don't have any witnesses, Your Honor.
All right.
We go straight back into
With
deliberation.
the defense not calling any witnesses, attorney's approach. Does the defense rest its case in chief as to sentencing? Do you also move to adopt and incorporate by reference the record? All right. Y'all approach.
This is a whirlwind sentence. I've never seen it go that fast. I've never had nothing be admitted. The picture was not provided to the jury, so it's not admitted. The picture was sustained as to the objection. Did not come in. TTU Gator, thank you very much. I can see who you're cheering for based on your profile picture and your name. We don't know what the picture was. It was never shown to us, and they never really told us what it was, but guilty on all charges.
All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family, home, and environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows. Quote, as to count 1, we the jury are unable to affix the punishment. Close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count 2. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count 2, we the jury sentence the defendant Carly Madison Gregg to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 2, we the jury sentence the defendant Carly Madison Gregg to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows. Quote, as to count 2, we the jury are unable to affix the punishment, close quotes. All right. First closing by the state as to sentencing.
This will be brief.
Mr.
You
Bailiff,
won't have a
7.5
full
minutes. You wish a 2-minute warning or a 1-minute warning?
7.5 minutes.
1 minute. You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life. When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets, when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You had to watch that terrible video. We listened to Ashley Smiley's last sounds. We heard from Heath Smiley on that 911 call, the desperation. He said, help me, help me. Ladies and gentlemen, those crimes were awful. She has shown zero remorse for what she has done. Let's talk about her ability for rehabilitation. The defendant's own expert during the guilt phase of this trial said, you know, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime and that she's continuing to have these disassociated spells. And obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole. If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters. Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately, we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smiley, and the attempted murder of her stepfather, Heath Smiley. Thank you.
Only took 4 minutes of the allotted 7.5. Defense now gets the same
Argument as to
chance.
sentencing by the defense.
Thank you, Your Honor.
How much of a warning would you like, Mr. Camp?
2 minutes, Your Honor.
2 minutes. 15 minutes total.
Thank you, Your Honor.
Ooh.
Yes, sir.
I'm going to have to tell you, this is probably the most difficult thing I've ever had to do. I respect your jurors, and I respect your verdict, and I totally understand that. And now I'm in front of you. Gregg, when this happened, was 14. She's 15 now. Her family's sitting on the front row. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. He's smiling. Who's the victim in this case? He has been supported. This is a family that's been torn apart because of this. This is extremely, extremely difficult on all them. And I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. You have 3 options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you, let the judge make the determination. We don't want you.
They already know
to
this jury's convicted her.
Give her a
within
sentence
2
for life
hours.
in prison. Life in prison is life in prison.
There's no parole
That's
in
it.
Mississippi. If life is
14-year-old.
life.
She can come out of this at some point. Anywhere you were hearing, she can walk out here and we don't, first of all, we don't know. Usually it's a lot longer than that. I mean, a lot longer. So I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
This is a ballsy move. 3.5 minutes. Now we've got more time. 15 minutes total.
Closing on behalf of the state.
7.5 minutes for a final closing.
Ladies and gentlemen, Mr. Camp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again? We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in voir dire about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County, and my office is asking you to please sentence Miss Gregg to life in prison without the possibility of parole. Thank you.
It only took a minute for that. And with that, the jury.
Ladies and gentlemen, the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits.
Start of the timer again. The hundredths of a seconds will fall off here in just a minute. Jury deliberates one more time. If it only took 2 hours to reach this, there are three options here. But it might be harder for the jury to all agree on this last one.
Mr. Bailiff, they still have the verdicts, the evidence.
Yes, sir.
All right, if you would take those to them. All right, we'll be in recess till such time as the jury reaches its verdict regarding sentencing.
This is happening now. There is no pre-sentence investigation. The jury could come back with a life without parole sentence, which would mean in Mississippi, life means her life for all her natural life. So she would die in prison. There's an opportunity also for life with parole, but the jury doesn't set how long that parole is. The judge doesn't set how long that parole is. Instead, that would be determined by the parole board, and there's no real guideline. Normally, they're saying normally it would be minimum 10 years, which is, if it is, that's a better deal than what she got on the plea deal, because I think they wanted 20 on the plea deal. But if the jury doesn't grant that parole, there will be no parole for her. The third option is if the jury wants to wash their hands of this and not make the choice, or is unable to make the choice. In that case, you're going to have the judge then step in. And that, I think, is a really ballsy move for the defense to say, please. And literally, he did everything but get on his knees and beg the jury not to sentence her. Instead, he says, let the judge do it, because the judge understands what's really happening here, and he had to be careful there. He was walking a fine line because they've also said, the jury's been told nobody knows this case like you do. You know the ins and outs of this case. You've seen things everybody else we have not seen. You know all this case, and now at the same time they're saying, it's too much for you. Without insulting the jury, don't put yourself don't carry this burden. Let the judge do that. It's also tough because the judge has been very, very firm and aggressively admonished the defense throughout the trial and especially pre-trial. Wow. Let's do a quick poll as we await the jury's results here. We'll see what you guys think. Hang on one second. I've got a call coming in.
Call from Sarah.
Sarah, are you our court watcher today?
Hi. Yes.
So you're down in the courtroom today. We just finished watching the verdict come in. We watched during the verdict. We watched Carly keep eye contact with each of the jurors as they were polled, as her eyes went to each juror. A lot of emotion. What did you see during that?
The jurors, you could tell they weren't having it. There were 4 men and 8 women. It was interesting because they kind of split themselves apart. The top row was all younger and the bottom row was all older people. But you could just see that they weren't buying what she was selling, quite honestly.
If it was that apparent, that explains why defense begged them not to return a verdict.
Yes, and to see it, like I told you before in text, I have a feeling Mississippi doesn't play, period. It's kind of the good old boy system, and I just had a feeling that's how it was going to go. Now, Carly's grandfather is right in front of me right now at his car. He just went out and got a cigarette.
Man, this must be
I had to rush back out because I kind of illegally parked when I got here because I got here in such a hurry. So I had to go move my car quickly.
We won't tell anybody. Let's see. All right, we're putting a poll up right now for the jury vote.
But the defense attorney and Carly, I know you can see it on camera, but it's nothing like seeing it in person. It's almost, I don't know. There's some kind of strange situation between the two of them, it seems. Like that's her pseudo mom now or something.
The defense attorney has been. Yes. We saw her like smoothing Carly's hair yesterday.
They're hugging big time right now when I walked out.
Yeah,
like full on embracing.
Wow.
It's very interesting.
I'll say this on both sides, on both prosecution and defense. I get the feel that both the ladies on prosecution and defense believe 100%
they do not like
their
each
side.
other.
They don't like each other, but they
Yes.
believe their side.
Oh, you can tell. Yes.
So
They
defense
keep shooting each other looks.
They're not going to lunch together. Is that what you're saying?
Oh, definitely not.
Wow. Tell me about the courtroom as far as people that were there. Is there a lot of support?
Okay. No. I would say no. There were the whole front row. It was her grandparents, her stepdad. I couldn't tell because I was behind them, but the lady in the blue plaid shirt, the few times I kind of caught the side glance, and to me, she kind of resembled Ashley. I don't know if that's Ashley's sibling, maybe. And there was another younger person sitting on the front row, and there were most of the people behind them, which is where I sat, way in the back on that side, were sheriffs, deputies, and other people in different kind of Rankin County shirts.
Yeah.
On the right side, it was just a mix, and a lot of them were reporters.
So as far
there
as
was maybe 40 people in the audience.
Okay, which is respectable. It's not a massive courtroom, right? It's just like
Right. No, it's small.
Tell me about the jury a little bit. As far as the makeup of the jury, did you pick anything out of significance when you observed them?
Not just the first thing I did was count. The men and women. Mm-hmm. The one interesting aspect I did kind of pick up on, besides the fact that they separated themselves, it seemed to be by age. The foreperson, she sat at the very end away from everybody else. which I thought was kind of interesting.
Possibly just the person with the best handwriting, the way the judge spelled out the duties of the
Maybe.
foreperson.
But she didn't sit with the rest of the jurors. She sat like 3 feet down away, like completely separate from the rest of them.
Huh. That's interesting.
Mm-hmm.
Closer to the judge?
And I got there and yes.
Okay.
Yes. And I'm trying to rush in, make sure my phone's on silent, all that. And I get there and I'm like, I could hear hustle and bustle going on. And I said, which way to the, and he said, right here, which was directly behind him. He said, but do you have a phone? And I said, yes. And he said, you can't take it. And I said, well, can I just leave it with you? And he said, I'm not responsible. And I said, it's okay, I trust you. And I threw my phone in a little basket and ran in.
That's awesome. Glad you made it there. I know you were rushing to get there. And this was a quick deliberation, under 2 hours of deliberation.
Honestly, I thought 2 to 4, but I really just felt the way the people are in this community that it was going to be guilty all across.
Yeah. It sounds like there's probably a good chance that this jury might also, there's a spam call. I'm not going to take that one. Sorry. Are going to give her a sentence. And if they were not buying it at all, life without parole is.
Well, look, and here's the thing. When the defense attorney got up there and was talking, he was so soft-spoken at that point, we couldn't hear him. So we could hear little words here and there, but I don't know exactly what he said. But the way the jury was looking at him, it was kind of like, yeah, whatever. Type, they weren't having whatever he was saying.
Yeah, he basically started, he talked about and said, pay attention to her age. She's a kid, right? She's a kid. You've got to think that in. And then he went straight from that to, please don't give her a sentence. Just let the judge do it. Let the judge do it. Let the judge do it.
I heard that part, and I saw him act like he was wiping his eyes.
Yeah.
He was, tearing up. I'm not sure.
I haven't seen a lot of emotion from him. He has not appeared to be close to Carly throughout the trial.
Right.
And all the times when Carly has questions or doubts or a disagreement or anything, she's always turned to the lady to her left.
He looks right at her.
They've been very close, and the other attorney has sort of been like an also there type situation.
Right.
Man.
Right. Yeah, I don't know. Now, this may take longer than the actual verdict. I'm not sure.
Yeah.
There were 2 or 3 that men and women that appeared to be quite young. The rest were I would say 30s, and then the other half I would say were 50-ish. Just by appearance.
I'm thinking about this. I don't know this judge's reputation. We know that we've heard that he can.
I do.
Can have a temper.
Just locally. Yes, and very cocky is what he's known to be.
As far as sentencing, is he a firm judge? Is he somebody that is known to be stern or really come down
You're
hard on
going
people?
to find that in Mississippi. I think for the most part, you're going to always find that. Yeah. It just seems to be the way. Now I know in the past in chat we were talking about if she gets the insanity. But my statement was, I've worked at Mississippi State Hospital, not when I was an RN, before I was an RN, and I would take prison over going there any day. Yeah. It was not a pleasant place to be by any means.
Yeah, it
was quite
the state hospital is not like something you want to seek out and say, yeah, I'll do that. It's not going to be fun, not at all.
Exactly. And actually one of the nurses on the building I worked on at the time, and this was years ago, was killed in a linen closet and then FA'd by a patient.
Whoa.
So, yes.
Yeah, unfortunately, those hospitals have people that, anything can happen because a lot of them are literally out of their minds. If you're not, you're not out of your mind, if you're faking it, that is the last place you want to be.
Absolutely. Absolutely. I lasted 6 months there, and it was all I could do to go to work.
Man, that's wild. All right, we're going to keep our ear to the ground and listen for developments here on the verdict to see if they come up with a verdict. We might do a quick lunch break. If you hear anything,
right now.
Whoa! Oh, we've got motion in court.
What's up?
We've got motion in court.
I told you I didn't think it would be long. I don't know. I didn't think it'd be long. Okay, I'm gonna hop on and watch y'all then.
All right, we'll see you. Bye.
Okay, bye.
Thank you so much, Sarah, for being our eyes in court here today. We don't know what's happening quite yet. Let's see. I've got another call. Just one second. Might have to cut this one short.
Call from Tiffany.
Hey, Tiffany. We might have action in the court right now.
Oh, well, I wanted to be really quick, and so I'll be quick. Some people might not like what I'm going to say, though. I just would ask the chat to be kind about the family and the stepfather. There's a lot of people saying that he looks like a creep, and it just seems inappropriate. There's nothing been brought up that he is anything but a kind person doing what he feels like he has to do. So that's the only thing I wanted to say.
Yeah, I agree. Thank you very much, Tiffany. There's nothing at all supporting any of those. Basically, a lot of people
feels so inappropriate.
A lot of people can't understand why he's doing that when he was a victim and he's standing by him. That is hard for me to understand, but still.
And it's going to be hard for any of us to understand because we've never been in that position. But that's all.
Yep.
That's all
Tiffany,
I want to say.
I'm so glad you said that. I agree
All right.
with you 100%. Thank you so much. We'll see you.
Yeah, have a good day. Bye.
You too. Bye. Thank you, Tiffany, for that. Everyone's still sitting around. Carly's not here. I haven't seen an announcement, but the camera's back on as if they expect something any minute now. They've been gone for 10 minutes. I mean, they just got the paperwork. So if they've got a verdict already or a sentence already, that'd be crazy. We can see a little bit of light on the door when we see the wall here. We see some shadows on the wall as people coming in and out of court. It looks like that's just reflected light through the doorway as it opens and closes. Does anyone think she'll appeal with ineffective counsel? Well, the judge has told both sides to appeal just to get the Supreme Court to make a decision and rule on, to get some case law basically in the books on some of the issues the judge has struggled with in this case. Particularly, there was an issue during the trial, and it came up during preliminary stuff as well, that the prosecution wanted to exclude portions of evidence or testimony based on legal reasons to exclude, whether it was, it was too late, whether it was inappropriate testimony. They had like 3 different reasons on why it should be excluded and had law backing that up. The problem is, on appeals, the appellate court has been overturning decisions where that request is granted. And so the judge had to basically allow in stuff that he said should not be allowed in. For 3 reasons it shouldn't be allowed in, and I have to allow it because otherwise I'll get overturned on appeal. And he's saying, so please, do appeal this because he wants this issue fixed. In the state of Mississippi, he said, this is the state we're in right now, and it sucks and it's wrong, but there's nothing I can do. My hands are tied. So I think there will be an appeal on here, at least to possibly address that issue. People are coming into court, so there may be a decision already. It's remarkable if it was. That's super, super fast. And I'd say if it was, that would be life without parole, just immediately. Ineffective counsel. I don't know about ineffective counsel. Defense has done a couple things that seem wrong. They've missed deadlines. They have, and by missed deadlines, I mean they have not filed responses to motions by the prosecution in the time that was required by the judge, and as such, the prosecution, the ruling just went by default to the prosecutor, and that happened for at least 2 of them. We heard that in a motion just a week ago. Those were still happening. There was stuff happening before as well. There have been delays. There have been all sorts of things that are just inappropriate. We've seen during court, especially, some like one move I'm thinking of was the beginning of the defense closing. Here comes Carly. Looks like. Wow. If they did this in under 15 minutes, this is crazy. We've seen that in the defense closing, they tried to use an inappropriate argument where they appealed to the emotions of the jurors, saying basically, you don't want this on your conscience, waking up every night. And we'll be quiet here. It looks like we're starting again.
All right, the bailiffs inform me that the jury has a question.
Question. Okay.
Jury's question is, what is life in prison without parole? ? Ears wise. Attorneys can approach. Look at the note.
I think that was covered at least twice during the trial. The jury can't explain the law to them. The
Anybody need
judge
to review any
might
further?
be able to.
All right, we'll mark the C next in number for ID purposes only.
Life is life. Her life. She would die in prison.
All right. Well, the truth of the matter is that the truthful answer to that question is nobody knows. However, typically all the court can say is something to the effect of, you have received all of the evidence and instructions in this case, please continue your deliberations. I'll hear arguments from the state as to response
No argument, Chairman.
by the defense.
No argument, Chairman.
All right, I'm going to ask Ms. Butler or Ms. Eaton to write that out. Y'all know my handwriting's bad.
The truth comes out. The truth comes out. Most judges don't write their own motions, rulings. There's another I love you. It'll be okay. I love you, I think was what we just saw from Heath, stepdad.
Instructions in this case, period. Please continue your deliberations.
Judge is narrating or narrating the note that's going to be written out for the jury to receive back. I think it's going to be sent back. It doesn't look like the jury is going to be coming back in to hear this. A lot of emotion
I'm
here.
going to ask counsel for both sides to approach one more time. Look at the note. Make sure you agree that's what it says.
Come read the chicken scratch. Should be pretty
Any
easy.
objections by the state?
No, sir.
By the defense?
No, Your Honor.
All right, I'm going to ask Ms. Butler to make a copy of that. I'll mark the copy C next in number for ID purposes only. The bailiff will take the original back to the jurors.
Quick copy machine run. You can hear it in the background.
I'll take a copy. The copy of the note will be marked C next in number, C4 for ID purposes only. Mr. Bailiff, you can take that note to the jury.
We'll be in recess.
We'll be in recess till the jury reaches a verdict.
All right. So the fact that they're asking this question means that they're deliberating between the two. It means that they're not giving a lot of credence to the imploration of the defense, if that's a word, where they said, please let the judge make the decision. Instead, they're saying, hey, tell us more about these, our two choices here. Tell us more. Now, it doesn't mean that they won't come back with the judge, you have to make a decision. Because if they are hung on this issue, the finding to come back is we can't, it has to go to the judge because we can't decide, only because we don't agree. We do have a poll up right now with what the jury would let's see, what sentence will the jury return? We've had about 1,268 votes. I'll give you just a minute more to get that into the polls at the very top of the chat window. If you don't see it, you can move your mouse up to the very top. It should appear. Give you a chance to vote. It's close. It's close. This is a much closer vote than we've seen in the verdict itself. I've got to think from what we've heard from Sarah, who's our court watcher, and from everything else that if the judge makes the decision, it could be life without parole.
Call from Debbie.
Debbie, hello. This is RA. How are you doing?
I'm doing good. I just wanted to say something about the stepdad because I don't understand why everybody thinks he's creepy, for starters. But he wasn't married to her that long. And, there's this thing called cognitive dissonance. I can't say that word, but
Cognitive
you know what I'm
dissonance?
talking about.
Yeah.
Yeah. And he's lost his wife. And Carly is all he has left of her. So he's going to believe that, yeah, that wasn't her. She has a mental illness. She didn't mean to do this. Something is wrong with her. that's why he's still holding on to her, because that's his wife's baby that she loved, and that's all he has left.
Yeah,
I mean, and now he's lost that too.
I don't know what he's thinking. Because I've never been in that situation. First of all, I've never been. I've been attacked with a gun, but I've never been shot. At least with a firearm. I've been shot with air rifles. Different story. I don't know. I can't fault him. I don't know his situation. All I can say is that it seems that everybody who knows Carly the best is rallying around her. That's what we know. Her friends,
And
her family.
forgiveness is healing to the person that forgives too, not the person that is being forgiven.
Yeah.
So that's like when people are like, "Oh, I just can't forgive that person." I always say forgiveness is for you. It's not for the person you're forgiving.
Yeah, I agree on that one as well. It helps you more than it helps the other person.
Mm-hmm.
Thank you very much for the call. Appreciate it. We'll continue to watch here. We might have a sentence here in just moments. So,
okay.
Thank you.
All right. Bye.
We'll see you. Bye. All right. Interesting question from the jury. How long? What does life mean? Basically, I heard it twice. I think we heard it twice today. That life means life in Mississippi. That there is no parole. Life without parole. Now, what does that mean in years? I think the judge is right saying we couldn't say that because we don't know how long Carly will live in prison. We also don't know if at some future point down the road, if the state of Mississippi decides to change their laws and suddenly life without parole becomes life with the possibility of parole. That's a chance.
Call from
Sarah's passenger seat.
Donnie, I give you one chance here. I know you're busy taking care of the internet. What's on your mind?
No, she just wanted me to tell you that her car's all right, even though she's parking in a handicap zone. I'm sitting in the passenger seat. I'm also smoking a cigarette. Everything's fine. All right, man. Bye.
Donnie, always the comedian. Appreciate that. Donnie's not down there in the courthouse, for those that know. Donnie did win the internet today. He was first in chat, so we have him taking care of the internet for us. His mother's gone. The family's upset. They are upset. They're rallying around her. Either Carly is really good at manipulating people, which there is some argument to support, even from her own words from her journal, or they see more than we see, because all her friends, the friends who care about her, these are not friends who are like, the bad influence friends who just wanted to do bad things with them, all those, the bad peer pressure people. These are friends that are worried about her and went to her mom and saying, hey, we're worried that Carly's doing this. They are still her friend, still sticking around, still staying with her. The parents of her mom that she shot and killed are still supporting her. They're every single day in court, the closest they can possibly be to Carly. The stepdad is there. He just is a smiley person, and that's his last name. He's just Smiley. I don't read anything more into that. There's a motion for mistrial in Young Thug. Which number of motion for mistrial is that? 30 or 40? So much going on. Let's see. So the lesson in this trial. I'm going to delete this one. That's guys, give the mods a break here, and please keep your comments appropriate. Alleging things that are not supported by fact are not okay. I'm hesitant to answer the phone here because there's some comments in chat that just really should not be said. So please let's dial it back a little bit. I'm going to cut people off if it goes askew on the phone as well.
Call from
Yeah.
To accept, press.
Is it Babs?
Hi.
Hey, how's it going,
Babs? It is Babs.
What's on your mind?
I just want to give a perspective from somebody that got thrown into grief. Mm-hmm. You don't process grief until after at least 3 months, you're just numb. This poor family hasn't grieved. None of them have grieved.
this
So
is a
they
good
are
point
just-
that you have to bring up the fact that the murder happened in March.
Right.
And that seems unreal for those of us who watched a lot of trials where we're talking about, what year did this happen? It happened in March. Young Thug trial was underway in March. Okay, this was not long ago, and so we're seeing a family of victims and the family very soon after this happened, and in all of that, they've also got not just the dealing with the grief and everything else that's going on, but they have this court case that's rapidly progressing, and we're already at a verdict here, just a few months later. That is a great point, Babs.
All they know to do is put one foot in front of the other. And what comes natural in that is not necessarily thought out. So I want to cut them all kinds of slack and give up prayers for them once Carly is dealt with, because they're going to be in a world of hurt for everything that's happened. And they're going to need lots of help.
Yeah. Babs, thank you very much for that. I appreciate that.
Sure.
All right.
Love you.
Love you. Bye. All right. I'm turning the phone off for now, if that's all right. We'll miss out on Sarah's updates from court, but let's see. Yep, I'm gonna mute it here. I apologize. All right. We've had good comments. The mods are working overtime trying to police chat a little bit. Mods, feel free, 24-hour timeout. Anyone who tries to insinuate there was any sort of essay involved with the stepdad, that will get you a timeout for at least 24 hours. First of all, we don't like getting sued here, and I imagine you don't like getting sued either, and that's something that takes you right squarely into that position. Let's see. Appreciate that. Let's see. Where's Amber? She came by your house and she vanished. She was alive when I saw her last. That's all I can say. We did invite Amber to stop by. Amber's one of our great mods. She's helping us on a couple fronts with websites and things like that. She was, I think, the only person we've allowed to come visit the studio that isn't already like a local neighbor. So Amber, yep, she's alive. She's in chat. She's posted something, or at least somebody on her account posted something. There she is. Right there. All right, we're going to give the jury just a few more minutes. They've now had half an hour to deliberate on the sentence, and the sentencing phase was the fastest I've never seen a sentencing phase that didn't have at least some testimony. Instead, we just had very brief closings. Didn't even take the allotted time on all three parts: the opening, the defense, or the closing from the prosecution. Left a lot of time on the table, and the jury's back out deliberating again. They might still miss. I guess it's lunchtime now. We might have a longer delay because of lunch. I can tell you, Amber can now vouch for the fact that I live in a very old house that constantly needs to be repaired, because she's seen it. But more pork chops on the menu? Maybe. How far back do you need to go for a verdict? The verdict happened about an hour ago. Now watch for the verdict timer. The verdict timer is going to stop at about 1 hour and 58 minutes. So it was just under 2 hours of deliberation time for the jury. And you should feel special, Amber. I loved meeting you as well. I'm sorry I rushed you off because I was live at the time. I literally had to run from the studio to run outside and take a picture and say hi really quickly. Yes, but a gorgeous house. It has a lot of personality. Oh, we do need to end the poll. Thank you very much, Samantha, for the reminder. The poll, this particular poll has to do with what sentence will the jury return. Always good when we end this poll before the jury does it. And results are in now. Let me read them off to you as they come in. Looks like Life with opportunity of parole was 42%. That's the majority. Life without parole, 36%. And let the judge decide at 20%. I have to say, for me, being on this jury, this is a hard decision to make. And it would be very, very tempting for me to say, let the judge decide. I don't want to be the person that decides this. The judge, you've got to imagine, the judge has sentenced other people for this specific crime. And so he has all that experience of, well, there was this heinous crime, and there was this one that just barely met, it was almost excusable, but then not quite. The defendant, went too far in what they did. He's got this full gamut of experience in sentencing people, and he's got to be thinking about that, saying, where does this one fall on this scale? Did I say life without parole was with parole? You clicked the wrong button. Yeah, sorry. It happens all the time. Hey, Mrs. R.A. Are you coming in? You brought candy. You brought chocolate. I'll let you borrow my mic for that. Do you want some headphones so you can hear what's happening? Mrs. R.A. brought chocolate. This is Dove. I think it's Dove chocolate. The red ones are yucky.
They're dark.
They're dark chocolate.
It's true. Those are not my favorite.
The gold, I think, have caramel.
Yep, those are good.
And the blue is milk chocolate. So
do you know why I bought those?
For me.
How bad I am. Yeah. When I was in Utah, I bought Mrs. Kavanaugh's chocolates, which are
delicious.
So good. And I was just dealing with all the stress of starting school and everything that we had to do, and I was eating
I was eating my feelings, is what she was saying.
Yes, I was eating all of my feelings in the form of Mrs. Kavanaugh's chocolate. I was like, no, I need to save that.
Do we have any more left?
Oh, we have tons. But
why don't you bring me that instead of this wax?
Because I'm saving it.
Dark chocolate is good for you. I don't eat chocolate because it's healthy, Ricky. That's not what I'm doing.
Did they just stand up? Are they standing right now?
No.
Oh, that's in the past.
Yeah, that's a different case. I'm watching. We're watching camera 2 is what's camera 2 or camera 3 is what you need to watch.
Gotcha. Yes, I hoard my chocolate and my books.
It's good. It's still good. Dove soap is delicious. No, this is Dove chocolate.
Probably
Very
the
similar.
same company, actually.
I might need some water. Can we page?
I know. You have
Page
water.
one of our child. Where? This is old water. I need new water. I don't know. I think this was here before I went on vacation.
Oh, well, you know what happened to the rest of the stuff that stayed here while we were on vacation?
Unfortunately.
What could go wrong? Ooh, somebody likes dark chocolate, like as your preferred chocolate?
Send us your address. Mrs. Ari, let me go over what happened today, just so we can
Yes, please.
Get you caught up. First,
I'm sorry, I'm eating into
finish
the mic.
chocolate. Man, it's delicious. That's really good. I hope you guys all get some chocolate today.
I start with dark chocolate as like a palate cleanser, and then I eat the good stuff.
No, that it taints the second one.
Oh, these are not the rules.
Okay, here's what happened today. The Carly Gregg trial reached its conclusion. Today was closing arguments. Jury instructions were pretty straightforward, nothing really fancy there. There were 3 charges they had to deliberate on. First was first-degree murder, second was attempted murder, and the third was tampering with evidence. The closings were phenomenal by the state, especially the second closing. Just hit a home run.
I didn't see it. What did they do that was so good?
Well, mostly it was in contrast to the defense. Defense was all over the place. The timeline, the thought process, the complete sentences. Defense seemed to be rambling, repeating things, and just they were like clutching at straws a little bit, taking a tiny piece out of one witness's testimony that was for the state and saying, I agree with this part. This is a unique situation, and there was no order or rhythm to it at all. It was tough to follow.
What's their argument?
Their argument is that she was insane. that she didn't know what she was doing at the time.
So can you define, or did they define insane for the purposes of this case?
Yes. In Mississippi, the definition of insanity is that at the time of the crime, the defendant did not know the nature and the quality of what they were doing. Or if they did not know that what they were doing was wrong.
Okay. Which way are they trying to push? Are they saying that she didn't know, or that she didn't know it was wrong?
Well, they've been trying to say that she had a dissociative moment where she literally it was like an out of body experience where something else was controlling her body at the time. Like it was like she didn't remember anything that happened during that time.
Poltergeist? Like, is that the
sort
thing?
of, but it's a tough argument to make because during that block of time that they say Carly was disassociated, she talked to her friends by their names, by their nicknames. She made rational and thoughtful, or at least premeditated motions, including like being aware of where cameras were, texting her dad on her mom's phone, planning things. It's all the behavior we saw, and we saw it on camera. It was not congruent with the DID type moment.
Gotcha.
So
because when you're disassociative, your brain is in lockdown. I'm simply trying to survive, and that's it. It's not.
Yeah. Imagine like having a brain transplant and someone else.
I have to try that again. Prefrontal cortex. There we go.
What did you say?
It was. I don't know. It was not English.
Imagine having like a brain transplant and somebody else having those memories for a period of time and then being transferred back. That's typically how they try to say that disassociation works.
What? No, describe that again. What?
Imagine having somebody else's brain put in your body, your brain taken out. So everything that happens, all the experiences, the thoughts and everything are going to this brain, and then your brain comes back and you have no memory about what happened.
So it sounds like if you have, like when I got my wisdom teeth out, they put me under, and I was like, it was gone. That time is gone. Is that what we're talking about?
Yeah, something similar to that, but this would be more of a mental health situation instead of a drug situation. Drugs can induce this. It most often occurs, and this testimony came out during trial, that it most often occurs in somebody who's experiencing a traumatic event, not necessarily a person who is perpetrating the traumatic event.
Okay, and I don't disagree with that, but I have to say that I do believe that for a lot of people, perpetrating the traumatic event is traumatic. Like if you're going to do something horrible like this, it may actually traumatize yourself, which, may I just say, is the premise of that book.
Which book? Are we talking about?
Of Crime and Punishment.
Oh. I didn't get that far. I'm still on chapter 1.
That book is the most disturbing and yet
it's your book. This is your bookshelf.
I know, I like it. Oh. I'm just saying that anybody would hold that book up as like, hey, I want to do this. It's like, oh, you did not understand that book.
We've got a little. I'll read the preface to Crime and Punishment. This book was referenced in the trial itself. This was a book that Carly said she was reading. The testimony was that she did read it. It's a heavy book. It's not a book that
I would not read it at that age.
I wouldn't read it at this age. Okay. It says this. Here's the opening. In the whole literature of the ambivalent relationship between man and the crimes he commits, Crime and Punishment stands supreme for its insight, its compassion, and its psychological fidelity. The story of the murder committed by Raskolnikov.
Yeah, it's a Russian name.
Raskolnikov. I think
Raskolnikov?
Raskolnikov. His punishment and atonement is the most gripping and illuminating study ever written of a crime of repugnance and despair, and the consequences that arise inevitably from it. In the author's mind, crime is its own punishment, and retributive justice can never be so severe as the penalty the human soul can impose on itself.
Interesting.
I've
read that, but I don't know that I would have described it like that. That's a great take on that.
That's pretty much how the defense described it. The prosecution described this book as like how to commit murder and get away with it, and that Carly was using it.
Yeah, okay, so
that's what the state said.
That's the first part of the book. That the whole premise of this book is the guy Rostovsky, I don't remember his name, that he he said, hey, I believe that there's a class of people who have different responses to the world and that they can actually do things like commit murder and not respond negatively to them. They're not going to have a problem. And he uses Napoleon as his example. He was like, when Napoleon went around, he killed lots of people and everybody's super proud of Napoleon and never bothered him. And so clearly he's a higher level person and he doesn't, and I want to be like that. He says, I believe that I'm the kind of a special person who can get away with murder and not feel bad about it. And if I am that kind of a person, then clearly I am higher level because I don't feel bad about it. And so he goes off and he does kill someone and he feels terrible about it. And he's sort of really, he's having a hard time dealing with this. He's like, wow, I must be a lower level person. At the same time that he's just dealing with the reality that you do feel like garbage when you do something as heinous as kill somebody. So that's the premise of the first part of the book. And then it does get into atonement at the end, which I love that part of the book, but I don't think that's the part that they're referencing in this trial.
We did see aspects of Carly having superiority type thoughts or even voices in her head. She described a male voice she heard in her head that would tell her things about her being better than other people. And she kept track of that in her journal as well.
So when she kept track of it in her journal, did she write it down like, I feel like this, or the voice is telling me this? Was she analyzing it from the point of view of, hey, why is this voice talking to me? Or was she more like, yeah, I am kind of special?
She was not journaling in the style of a 14-year-old girl.
What was
I'll
she
tell
doing?
you that. She was making lists of things that she believes. And she believes there's no God. You can, choose your own destiny. She chose things. She says things about, of the four elements: earth, wind, water, and fire. I choose fire because it's, it's beautiful, it's destructive, it's powerful, and deadly. And those are things I want to be.
Okay, she failed chemistry. There are more than four elements. That's a really old idea.
Apparently, the periodic table of elements just had not been taught in that class yet. But anyway.
But I mean, she's definitely advanced in her reading.
Very advanced.
Does she read Nietzsche? Because that's very much his philosophy.
We didn't get into a lot of what else she had read. I think there was one other book they talked about. But as far as book reports go, it was pretty much just Crime and Punishment.
Yeah, that's not a good book as far as, hey, this is how I want to form my life. That's not good.
She did write about manipulation and about how to manipulate and how she likes to manipulate and sort of encouraging other people who may manipulate to enjoy that journey of manipulating people, which was a little creepy.
That's a lot creepy.
Dr. Pickett absolutely, he analyzed every single segment of this, and it's worth going back and rewatching. He was phenomenal on the stand. He was up there for about 2 hours, and it did start to feel long at the end, but wow, just did an amazing job. Even on cross-examination, where they tried to discredit him based on his inexperience, his youth. He's only been board certified in some areas in the last couple of years.
But you liked him.
I did. I liked his style. He was an expert, first of all, that spoke in a way that the jury could understand. They a lot of times you'll see an expert that uses expert words to sound important, right? It's like you didn't have to use discombobulated as your word in that sentence, but a lot of times an expert will use the vernacular of their profession to show that they're at the top of their game.
As a flag.
And it leaves the jury way down here going, whoa, 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 what?
Yeah.
He doesn't do that. He spoke very plainly and in a way that just resonated with most of the people that were watching. Anyway, we want to say, so those three charges the jury had to listen to. I think defense nailed the closing. Dr. Pickett was the key witness. He was the Dr. Joe of the Maya trial. He was the Dr. Joe of this trial.
Okay.
You just did a great job. Then under 2 hours of deliberation.
I know.
And
I
he was
heard
guilty
that
on all three charges. So I'm fully bobulated, says Bob. I like that. I mix up the prosecution and defense. I apologize. In my head, I think faster than I talk. And then I say the wrong word.
Is that what's happening there?
Okay, I talk faster than I think. He was the nail in her coffin.
Interesting. So you feel like she is guilty then?
Yeah, I do. And I felt better with that verdict after listening to Dr. Pickett than before.
So what held you back? What was it that made you think, maybe not.
There was a lot of moments, a lot of testimony that I'd watched where I said, we've got that, something doesn't seem right there. Where we analyzed the video frame by frame really and picked out, the dogs catching on to things. The dogs were more observant to some things than I was in that video. But as we listened to Dr. Pickett, he took everything that just sort of didn't sit right with me and he explained it. And he said, this is what's happening. This is why. This is what this is called. And every single step from using the term of endearment when texting her stepfather, pretended to be her mom to lure him home. He went through everything, all the way through the actions, peeking around the corners, walking, facing away from the camera. Every single bit of it was explained in such a way that was rational, and there was no point where I had to leap to say, yeah, I could see that. It was like, yes, he just put into words something that I've been struggling to grasp, and it nailed it.
So I have a theory on the whole honey thing, but what was his?
Well, the term of endearment. She was literally trying to lure him home, trying to pretend to be her mom to finish out this plan. And it ties in with the fact that she, during this time, has also been texting her friends, and she's saying, help, I messed up, and she's telling that to her friends.
She
and the
said,
friends
I
are
messed up? I did not
She used
hear
the
that.
F word, but yes, she...
Because as I understood it, and granted I'm very spotty on this, but I thought that she was like, hey, woohoo, look what I've done. But she said, I messed up?
To some friends she did. She's reaching out to a lot of different friends. She's going through a lot of emotions, but she says she messed up, and the friends are worried. They say, hey, what's going on? And she's, texting other people, and they're like, look, if you don't reply, I'm going to call the police. She says, no, don't do that. You can't do that. Because she hadn't finished her plan yet. She still wanted to shoot her stepdad.
She said that's why?
No, but that's why. That's why she said don't do that. And the doctor explained that this was a rational, intentional process that she was working through, this plan.
So when you say she's calling all these different friends, is this in between the mom and the dad? That's when this is taking place, her contact with her friends?
In those 45 minutes.
45? I didn't realize it was so long.
Yeah. Anyway, so jury reached a verdict. We had Sarah in court who reached out. She was a court observer and watched the verdict come in. She watched, once the verdict came in, did you hear the sentencing phase?
That they are doing it right now?
Oh, just what happened. It was very, very quick. If you blink, you probably missed it.
Yeah, I don't know.
Sentencing phase is another evidentiary phase of the trial. It's not to guilt and innocence. It's just to the sentencing, and so they can present evidence that would support finding a specific sentence, because the jury is in charge of doing that here in Mississippi. The jury has three options. They can choose life without parole, which is the maximum she can get. The death penalty is not on the table for juvenile. That's a Supreme Court rule. They could choose life with the opportunity of parole.
Hang on, life, is that 20 years?
In Mississippi, currently as the law stands, life is life. If you say life without parole, you're not getting out. You will die in prison. You'll leave in a box. So that's life without parole. Life with an opportunity of parole on the other side is sort of this, who knows type number, because it's all up to the board. And it could, theoretically, it could be later this year, the board says, hey, let's bring her up for parole. And they're like, we're charmed by her. She's changed. Let's let her out. It could be that soon. Realistically, 10 years is probably the soonest she'll see that. But any time after that, and as soon as she's out, her sentence isn't over, but she's on parole. As long as she doesn't commit another crime, she's out in public. Had they gone not guilty as the verdict, she could have walked free this afternoon. But that just was not on the table for the jury at all. They were very quick in ruling that one out. The last option they can choose is that if they either cannot come to an agreement, because they all 12 have to agree on a sentence, if they can't come to agreement, or they don't want to make the decision, and I guess that can be a combination of both, the judge then makes the sentence, and it would then go to the judge to make the call.
Yes, and I saw that part where the defense was like, give it to the judge. And I was like, have you been watching the judge? I haven't watched him the whole time, but the little bit I've seen, I'm like, I wouldn't want him judging it.
This is what Sarah pointed out. As the defense was giving their closing, they were not buying it at all. And they read that jury like a book and said, under no circumstances do we want you sentencing our client.
They really think the judge will do better,
They're
though.
willing to take a chance on the judge who hates them. Let me just say, the judge hates them. He's willing to take a chance on the judge instead of letting the jury do this. But the jury, by the question they asked just, 10, 12 minutes into deliberation, was basically, tell us, what does life without parole mean? How many years is that? Let us know.
Yeah.
So
jury, because as far as I was aware, life is like, it's 15 to 20 years. That's a life. That's why people can have like 300 lives, which is still a lot.
Cats have 9.
Okay.
I'm not a cat.
I'm not a cat.
Anyway, I think we're going to do a quick break. We're approaching that, the magical 6 hour point. We're 5.5 hours into the live stream right now. At 6 hours, and this is just a technical side, just as a YouTuber, let me just fill you in on this. At 6 hours, as soon as we pass that by 1 second, YouTube removes the opportunity for us to make changes and edits and correct things. If there's a part that we need to cut out of the stream, they remove that option. And instead, all we can do is just delete the whole thing. Oftentimes on verdict days, there's times we need to take a little segment and remove it for one reason or another. Generally, it's for convenience dealing with bogus claims of copyright.
Right.
But so we're gonna have a break here before the 6 hours is up, and we'll just do a seamless transition and portal everyone over to the live stream. We'll just continue where we left off. A portal. So I'll set that up right now.
Okay, so I'll think of something to talk about when you do that.
Or you could get me some more chocolate.
I could do that. That'd be easier. Let's do that.
You could get me the good stuff.
I could give you the stuff I have here.
But there's good stuff.
Dove is not bad.
But I know there's better chocolate in the house.
You guys, the effort that went into getting that better chocolate here was amazing. It took so much work because you cannot let it get warm. And so we had to stick it in our cool chest and drive it all the way across the country. But we don't have a cool chest cooler thing. So we had Ziploc bags that we stuck ice in every single night. And then it just melted every day. And we'd clean it all out and do it again the next day. We worked for this chocolate.
It was rough.
Life's hard.
We used a
We're
lot
in the
of those
first world.
ice machines from the hotels.
Yeah, we did. I didn't know what those were for. It's to keep your chocolate cool across the country.
Speaking of that trip, how would you describe driving across the country?
Oh my gosh.
Would you recommend it?
I'm really worried because several of the people that we love dearly are not doing well physically. And you're just going to have to fly back and I will get on Zoom or something. The reason that we drove is because I have a medical thing that flying is just not possible for me. And so, yeah. So Scott can fly. The kids can fly. I cannot fly. And I also learned from this process that I cannot drive 8 to 12 hours a day. That's wow.
This was the part I was waiting for.
I'm wussy. So, yeah, I cannot do it. And I don't know what we're going to do. If we have to hurry back, it's just going to have to be you. I don't know what else to do.
What are we going to do when Brian Koberger trial starts for 3 months? In Idaho.
Take a month to drive there. Oh my gosh.
I'll
So
fly.
long.
You join
Let's
me.
move. Let's just move somewhere in the middle. And then we could drive either direction and have
The
it
middle is Nebraska. You remember Nebraska. Sorry, Thal. I realize that's home for you. The middle is Nebraska.
Nebraska's huge. It took so long to get through Nebraska.
It's like days. It's bigger than Texas when you're driving through it.
So long.
All right, we have set up the portal to redirect us over to the new stream, so we can do just a 2-minute break. We won't miss anything that's happening in court, I'm positive, because even if they came back right now, we would be back before court started. So we'll do a portal over. Hopefully, during the break, Mrs. R.A. can go get me some of the good chocolate and maybe some water.
You have legs.
I know, but I'm busy. It is wonderful to have all you guys here. I realize this is a heavy day. We try to have a little bit of lightheartedness.
I know. I came in here knowing that I have nothing to contribute to this conversation. I haven't paid enough attention to do it. But man, I can bring chocolate and laughs.
Hey, Greener says I have sexy legs.
You guys, that comment got like blocked. And Scott went in. He was like, no, show that one.
Just saying. It's No Pants Friday. We can't show them. We did see somebody walk by in the court. We're watching that, but nothing as of yet. All right. Is there anything we need to do? Let's move to Colorado.
Colorado's really cold. I am such a wuss, guys. I have a complaint for every area of the world.
Can I tell you how much I love ice fishing? Remember in Napoleon Dynamite, the movie, where Kip is doing his whole "I love technology"? He's singing. I love technology. I that resonates.
Scott, if
with
you're
me.
going to do that, you got to like really sing it.
I also love ice fishing. There's ice fishing is the great equalizer when it comes to fishing, because if we're talking fishing from like just on a lake, here's me standing on the shore with my $10 Walmart special fishing pole that Ayden purchased for me, and I'm casting as far as I can, and it limits me to that. And then there's somebody else who has the best bass boat in the world who can zip around the whole lake and fish wherever they want, and we're not equal. We're not equal. But when it's iced over, when it's frozen, we're all equal. I can access every part of the lake that anybody else can.
And the boat is like,
and then it just comes down to skill, and that's where I shine.
Skill in ice fishing?
Luck. Skill and luck.
Oh,
and
I
little
think
bit of
like
luck, more skill.
Endurance. You can just sit out there on the ice for a really long time, and that's what makes you win.
Yeah. Anyway,
Yeah, North
stick
Dakota.
bobbing is a big skill. Yeah, I love fishing. It's a lot of fun. I don't get to do very much of it anymore, even though I'm next to the ocean.
People do fish in the ocean, but it always makes me nervous. Oh!
We're not taking a break. We're not taking a break because we have action in court. Hold tight. We're not, well, I guess.
Where are we on time? Do you want to go right now?
We've got 5:40.
5 minutes and 40 seconds?
It's going to be quick. We're 5 hours and 40 minutes, so we've got 20 minutes. I think they can do this.
We've got 20.
I should have taken a break instead of told my ice fishing story.
That's what happens.
Okay. We're going to portal in 3, 2, 1. We have action, so we're going to.
Okay, see you guys all in.
Yep, it's going to be abbreviated. We're going to portal right now. When we come back, we have the sentence, we believe, possibly a question, but we believe we have the sentence in right now. So we'll be back in just a minute.
Look at her face.
Okay, here we go.